gentlemen, we are ready to resume. Mr. Collins, I remind you, you're still under oath. Go ahead, Mr. Dwayne.
Thank you, Your Honor. So last we were in here, we had watched at least part one of that second interview, right? Yes, sir. All right, and that interview was on December 7th of 2020. That's correct. Okay, having done the first interview on November 18th. That's correct.
They are in contact. Okay. Till Kianna shows up. Okay. Anybody come over? Did you go anywhere?
I didn't last week, so no.
How was his behavior Sunday?
Perfect fine.
Was that good?
Yeah.
Okay. There's no issue Sunday, was there? Nothing happened, no accidents happened, no setting up any point out?
Just Saturday when his arm got swollen. That's it.
Okay. And I was just out of the blue, nothing happened that you know what the cause was out of swelling?
No, because we had just been to the doctor about 2 weeks before that because he had a bag of chips and his whole face blew up. So she said, when I was there, she told me that he could possibly have another allergic reaction later on. So I assumed that that was what she was saying is.
Okay. So we're clear on, obviously, Tuesday morning. We're clear on Monday night. Clear on Monday. Clear on Sunday. Saturday, the only place you went was Granddad's. He was in your supervision the whole time. Okay. Real quick, Friday. What was Friday?
Friday I was to work, he was at daycare.
He was at daycare Friday. Okay. Where did she go?
He goes to daycare at a lady named Faye Park.
Faye Park. She got you for a PD. Is that a personal person? It's not like daycare.
No, she has a at-home daycare.
At-home daycare. Okay. Where is that at?
Right off the bus sometimes.
I'm sorry.
Right on the same road as Lawrence Middle School.
Do you have a phone number? So you do have any copy?
No, maybe I don't have that address.
It's 478-213-9661.
What time is he there Friday?
He gets there at about 6:30 in the morning.
And what time was he picked up Friday?
I pick him up at 6.
6 p.m. Okay. And that's what happened right there, 6:36. When you picked him up, was there any issues? Any complaints or anything going on then? He was fine all Friday night, he was fine all day Saturday, and all day Sunday.
Just Monday and
Okay. All right. Is there anything that we haven't talked about that you think is important?
just not really from what happened, but I've been asking just for so long for an allergy test for everything because he's had episodes of throwing up all the time from regular milk to whatever, and we even been referred to a pulmonologist. We never got tested. So I've always had concerns that it was deeper than just a breathing issue that they were trying to tell me, because every time we go in, most of the time he's not sick. They test him for everything and the breathing just happens. So
Well, I don't believe this is due to any kind of allergy. Okay. I talked with the medical examiner. Okay. What they have, the initial right now, okay, is he had a lacerated liver. Okay, he had blood in his abdomen. He had multiple contusions of his body. He had lacerations to his pancreas where it attaches to his body. Okay, there was no signs of any breathing issue that would cause his death. Okay. So there was something that happened to him. There was some type of injury to his abdomen that caused this to his liver and the contusions to vital, some sort of impact.
There's nothing that literally, I mean, he's never had any issues with his stomach. Never been hit. Nothing.
They don't think this would be from a fall. Okay, so it's not from a fall, it's just multiple impacts that cause the injuries, to the internal injuries. Okay. It's like, you hit the stomach real hard.
You know what? He doesn't even hang out with the kids in daycare.
Well, here's the other part of it, is that, I understand this is a Georgia Bureau of Investigation that does these autopsies, okay? They're saying that whatever caused these injuries happened within 24 hours of his death.
Nothing.
Well, there's some things that could have happened. There's things that had to happen. Something had to happen. You don't get this without something happening. So,
The child isn't even.
how does Mr. Benton, did he ever hit you?
No. Why?
And about yourself, how do you know?
No. I don't even hit my child. That's literally part of everyone's issue is that
Who's
I'm
this?
disciplined. It's wrong. I'm too nice. He's two. So there's no reason to discipline a 2-year-old when he's still learning.
Yeah. I mean, I understand. But something happened. And the only right now is, you were around it, Mr. Bennett was around it. And I mean, you go back far enough, Grandpa was around it. But you were supervised the whole time there, and that was well before 24 hours. Okay, pretty much he started getting sick, according to y'all, after lunch Monday. That's when his stomach started hurting, started going up. Okay. Who you been with between that time?
He's literally the only except for me. Thank you.
Okay. So the concern here, the obvious concern, okay, is that something's happened that either yourself or Mr. Bennett are concerned to tell us.
God, no.
Okay.
If there was something, I would tell you and he would tell you.
Okay. Well, I hope so.
Nothing happened.
Well, something. There's something. We don't.
There's nothing in my house that he could even run into. To the extent that he would hit. He didn't even, the child learns about everything. So if he would have hit something, he would have came running to me, he would have cried. He didn't even cry. So,
Do you think there's any chance Mr. Bennett struck him?
no. The child, no. There's just no way he didn't get his daughter.
Okay. Well, I'll tell you the only way to have a lacerated liver, multiple contusions of the bowel, a laceration to the pancreas, is from some sort of impact to that abdominal area. Okay.
No, in their right mind. And you're talking about within 24 hours. Absolutely not. I call
How often do you call?
30 million times a day, especially if someone has my child. And if you
You
don't want
call
to,
Mr. Bennett
yes,
every 30 minutes on
I
that?
call him. Every chance I get, I'm calling. And it has nothing to do with anybody. It has just to do with me always wanting to be around Carter and wanting to talk to Carter. So,
Should it be that you talk to Mr. Bennett every 30 minutes on Monday?
not every 30 minutes on Monday. I got classes, but
So I mean, it's important at this point that we know how often you talk to Mr. Bennett on Monday. How often do you think you talk to him on Monday?
I call.
go from that morning, because we know you come on Monday at lunch, around 11ish, is that right? That's 11, 7:15ish, back at 11ish. That's 4 hours.
I am on Robin, so I didn't leave at 7:15. I probably left at 7:45 because I was.
No, we had a video you leave.
Okay.
Okay. So, what, between that 7:15ish and 11:15ish, 11, did you call, how many times did you call me in that morning?
I don't know. I always,
Did you call all of them that day?
no, I always, there's no, and that is, no.
Wow. You changed your phone service?
No.
Okay, so is it your phone line and your phone service?
Yes.
Would you be willing to get your phone bill and show me? Because I'll need to know how often you called in that day.
We would have no issue now.
Was there any change when you called in that they just sounded different or?
No, like that's.
Because according to everything, it really seems like something happened. I think it happened after lunch Monday, whatever it was. I think it happened after lunch Monday after you left. And then he went downhill from there.
What you're implying,
Ma'am?
I said what you're implying, just is so bizarre, just because of who he is and who he has always been and who he
Always been?
Yes, like he would never, like never. My child literally loves him. My child calls him dad. And he doesn't even do that. There's just no way. And if Carter didn't like somebody, or if Carter felt a certain way about somebody, he would definitely not be around them, and I wouldn't know. And I wouldn't even know. I don't let anybody watch him except for babysitter and me and dad. That's just what it is. And that's just because of his breathing issues. I don't trust people with him in that situation. So if I would never leave my child with him if I ever thought that he was even capable. The man is not even capable of hurting a fly. So.
Well, I mean, honestly, he seems like a pretty decent guy just from my personal opinion yourself. But these are the facts, okay? There is no me changing this.
The facts are, there was nothing wrong with my child. And if something was wrong with Carter, or if someone hit him, or whatever,
Okay.
he's a crybaby.
What was his vocabulary with you?
Who's Carter's?
Yes.
Mom, my stomach hurt.
So he could say that much more?
He says he can say it really, but he's not even to the point where he's like saying full wrong sentences. He can mix words together, but if something is wrong with him, he's gonna whine, or he's gonna come to me and point and show me what happened, or show me who did it.
I'm gonna stop it right there, Judge. I give it time to stand there. Awful, and I don't have. Alright, so we watched all those videos are fair and accurate, representations of the interviews that you did with her.
Yes, sir, it is.
And after each of these interviews, she was free to leave.
Yes, sir.
So, I want to point out, so, in your interview with her that we just saw, you're working, you say, 24 hours. Okay, so this was December 7th of 2020, right?
Yes, sir.
And when did you end up leaving the sheriff's office?
February 21.
Okay. You aware that there was a big meeting between the chief medical examiner, the forensic pathologist that performed the autopsy, and other members of the sheriff's office, DA's office? Were you aware that any of that happened?
At a certain point, I was.
Okay, was it after the fact that it happened?
Yes.
Okay. But you weren't involved in that meeting?
No.
So at that time, you didn't have any information really other than what you've been provided, at least initially?
That's correct.
And at the time that you left the sheriff's office, you didn't have the final autopsy report?
No, I did not.
And the questions there, so you're asking about Kianna, right?
Yes.
And that something happened, at least with the limited information that you had at that time, you're asking in the context of what was Kianna doing at the potentially this could have been, Monday afternoon after you left. What is the purpose of trying to bring Kianna up? What are you trying to accomplish here?
Well, one of the things I'm trying to accomplish in this interview is go suspect list, a complete suspect list. I'm not sure anybody the child in contact with, or certainly 24 hours, but well beyond that, at least integrity. That was one of my initial objectives.
Okay. And at that point in the interview, you got any information to indicate that any person had done anything? Nothing further this time around.
Mr. Bird, please review.
Thank you, Your Honor. Good morning. Is it still okay for me to call you Sergeant?
Sure.
Sergeant Collins, it's always good to see you.
Sure, thank you.
Let me ask you several questions. Once again, you originally got the call, did you not, to go to the hospital, Peach County Hospital over in Byron, is that right?
Yes, sir, that's correct.
And by the time that you got over there, the child had already been pronounced deceased.
I believe that's correct. Yes, sir.
Did you, was Ms. Davis there?
She was.
Okay, did you interview her then, or talk to her then?
I had a brief contact with her before leaving the hospital.
And was the contact that you had with her that she needed to go back to the apartment so somebody can walk through the apartment?
During our conversation, I asked her if I could meet her apartment after meeting us.
And she did in fact comply with that?
Yes, sir.
And Mr. Benton was with her also, is that correct?
Yes, sir.
So it's well, let me ask you this: when the child was pronounced deceased, did you go with the child to the morgue at the hospital in Warner Robins?
I went into, it wasn't a morgue, I went into the room where he was located.
Okay, but when the child was removed from or taken from the Peach County Hospital to go to the morgue in Warner Robins, is that right?
I'm not sure where the child went after the hospital. I was told by the coroner he would be going for autopsy to the GBI's office.
All right. So I take it that you left from the Peach County Hospital and then went to the apartment there on Lakeview. Is that correct?
Yes, sir.
And Ms. Davis was there with Mr. Benton. Is that correct?
Yes, sir.
And also Officer Boytel was there from Warner Robins. Is that correct?
Yes, sir.
And at that time, you talked to Ms. Davis to see about getting consent to search the inside of the apartment. Is that correct?
Yes, sir.
Did you search it then, or did you wait for Officer Herrera to come, or Investigator Herrera to come from Warner Robins Police Department?
I waited for Ms. Davis.
All right. But in any event, you got Ms. Davis to sign a handwritten or makeshift, if you would, consent to search. Is that correct?
That's correct.
When the place was searched, was it just you and Investigator Herrera?
I don't recall who all was in the apartment. I believe it was one of the officers. Maybe somebody assisted me. I'm not quite sure.
Okay. Do you recall seeing Meredith Edwards from the Warner Robins Police Department over there?
No, sir.
Do you think it may have been Officer Boytel that went in to help search the place?
I'm not sure, sir.
Okay. Was the purpose of searching the apartment to clear it, or was it to gather evidence?
It was documented, so.
Document the scene. And at any point in time, did you yourself gather evidence, or did you just watch Investigator Herrera do that?
I just observed. I did not collect evidence.
Did you stay there through the entire time that Investigator Herrera was photographing and collecting evidence? Did you stay the entire time?
Yes, sir. I believe I did.
Okay. I take it that Investigator Herrera gathered quite a bit of evidence. In other words, pillows, and do you recall anything that he may have taken?
I don't know all the specifics of this collection. I didn't observe each collection that he made.
Okay. And that was documented?
Yes, sir. They documented each thing that they collected.
He would have done that just himself, or did you help him do that?
No, sir, he would have done that himself. I was not part of crime team investigation.
In gathering that pillows and do you know as well that he cut any of the carpet?
I do not know.
I mean, if he cut any of the carpet or taken samples from the carpet or bed mattress or anything of that nature, you would have seen that, would you not?
I was present, but I did not follow him around the entire time or help him collect him or anything of that nature.
In Investigator Herrera gathering this information, did he give it to you?
The evidence, the collection of
Right. So, to your knowledge, did he take it with him?
to my knowledge, yes, sir.
At this particular point in time, would you have been considered the chief law enforcement person investigating this case at that time?
At the time, I would have been assigned investigator.
Okay, and that would have been in conjunction with the War Police Department too, is that right?
Yes, sir.
The items that were gathered, I take it as standard protocol for law enforcement to take it back to their office and put it in an evidence vault, is that correct? Generally speaking.
Yes, sir.
Do you know if any of these items were ever turned over to you?
They were never turned over to me.
Okay, so I'm asking this question. Do you know if anything was turned over to the GBI?
I do not.
Okay, so you didn't do that, no? If anything was turned over to the GBI, that was not something that you did.
That I was involved in those.
Do you know if anybody else from the House County Sheriff's Department did that?
I'm not sure, sir.
Now, you testified that you left the employ of Sheriff Talton in February of 2021, is that correct?
Yes, sir.
So at the time that you left the employ of the Sheriff's Department, to your knowledge, this case had not been taken to the grand jury of House County.
The time I left, sir, I was still waiting on, the sheriff's office still waiting on final autopsy results to report.
Now, you've testified that, who was it, as far as this information that you relayed to Ms. Davis in this interview of December the 7th of 2020 concerning the injuries to the child, who did you get that information from?
The injuries about the child.
Right.
I was informed by staff at the hospital of his condition coming in.
Okay. So, I mean, did you receive this information from Danny Galpin, who was the coroner at that time?
Danny Galpin was present when I was at the hospital, and I did receive information from him.
Okay, so you received it from Danny Galpin.
I received information from different parties. So Danny Galpin provided information that he had, and then the staff at the hospital provided their information.
Was any of the information that you received in writing?
Not at that time.
Or at any time did you receive anything in writing?
I had statements later.
I'm not talking about statements from people that worked at the, can I take, did you receive the written statements from all of the employees at the pediatric place?
Yes, sir.
Okay. Besides that, well, did you ever talk to the medical examiner, Dr. Brown?
From GBI,
Right.
I believe I had a brief conversation with him on the phone.
And once again, all this information that you received was before you left the sheriff's office in February of 2021. Is that right?
Yes, sir.
Okay. Who was it that you turned the file over to once you left?
My lieutenant.
Lieutenant Meadows.
Yes, sir.
And at that time, do you know as to whether or not any of the items that were collected from the apartment were ever sent to the crime lab, not necessarily by you, but by any law enforcement agency?
I don't know, sir. He didn't at that time.
Now, we've watched these videos that you had with Ms. Davis, once again, one was on the day after, on the 18th of November, is that correct?
Yes, sir.
And the next one was done 3 weeks or so later on the 7th of December, is that right?
Yes, sir.
In between the time of the first and the second one, Ms. Davis had moved to the Atlanta area, is that right?
Yes, sir.
And once again, at no time did you ever advise her of Miranda rights?
No, sir.
That's right.
Yes, sir.
I recall in the first statement that she gave to you, November the 18th, 2020, that she was extremely emotional, was she not?
Yes, sir, she was.
And at one point in time, you told her, did you not, don't blame yourself for this?
I don't know that I can do the words, I have to look back. I recall saying, you couldn't have known while I was speaking with her what was going on.
But, you know, once again, the jury can recollect for themselves what they heard you say.
Yes, sir.
So I take it at some point in time between the first interview and the second interview is when you gathered information from either the coroner or people at the hospital or something.
Between the first and second interview, at one point I was contacted by the coroner and Gallagher.
All right. And I think you personally met with him
I spoke with him on the phone
for how long period of time?
a few minutes.
A few minutes. And did he ever reduce to writing anything that he told you?
Not while I'm sure at some point he did, but I didn't have that at the time. I wrote down what he said as he said it.
Did you later learn to understand that what was the reason for the delay in the autopsy report? Do you know?
I believe workload from the GBI.
Okay. Was there any concern about any toxicology reports or any other reports that GBI needed to do on the child's body?
That's all that was concerned being waiting for about sheriff's office.
Okay. And if you left in February of 2021, that was only like 2 or 3 months. Is that correct from the date of the death?
Yes, sir.
Okay. Would it surprise you to know that the autopsy report was not done until the end of September of that year? I mean, you were already gone by then.
I was gone, yes, sir.
Did you ever have a chance to go over the autopsy report?
No, sir.
Were you ever asked by the district attorney or anyone else in law enforcement?
I recently went over pictures from the apartment, but I did not go over the actual autopsy report.
And the pictures that you described, those are the ones that basically we've seen. Well, you weren't in here, but the photographs that were taken by Investigator Herrera.
Yes, sir.
Now, the interview that you did with Miss Davis on December the 7th, that was played yesterday and part of today, that didn't include the entire conversation that you had. Is that correct? Or do you remember? In other words, do we see everything?
Yes, sir. As far as I'm aware, I don't recall any other interviews with her that's not recorded. That's what you're asking.
Well, I mean, what I'm saying is there was more to the interview than what the jury is saying.
I concluded the interview at the end of this. And in this interview, she left.
And once again, she was not placed under arrest.
No, sir. She was never in custody.
Did you seek warrants against her?
No, sir.
Did you seek warrants against Mr. Benson?
No, sir. Would that have been your responsibility to seek warrants?
No, sir, not necessarily.
Whose job would it have been?
These type of cases, these cases get forwarded to the district attorney's office.
So there were never any warrants that were taken against Ms. Davis?
I never took a warrant against Ms. Davis.
Then, are you aware, based on what you know of the case, that there were never any warrants taken against Ms. Davis?
John, can we approach?
Yeah,
Sergeant, let me ask you a few more questions if I may. From the period of time that this event occurred until you left the employee of the sheriff, did you talk to Ms. Davis any other time besides in the office there at the sheriff's department?
I made contact with her by phone.
By phone? Did she ever make contact with you by phone?
She returned the call.
And would this have been after the conversation that you had with her on December the 7th of 2020?
Yes, sir.
In talking with her, did you advise her that you were leaving the sheriff's department and to be turned over to someone else?
I don't recall doing so.
Okay. Just a second, John. Should just hold it. Thank you. Thank you.
Anything else, Mr. Webb?
Just briefly, Your Honor. So I think Mr. Drew asked that at some point in the first interview, you may have said something about don't blame yourself or something to that effect. Do you recall that?
I recall hearing myself say that she couldn't have known in the first interview when it seemed to be a medical situation.
Okay. So you didn't have a whole lot of info at that time.
I'm still gathering information.
And there was some questions by defense counsel about whether or not any evidence went to GBI at all, correct?
Right.
And there was one very large piece of evidence, for lack of a better way to say it, that went to GBI, right?
Referring to the deceased.
Yes. His liver and his body.
Yes, yes.
Nothing further.
Anything else, Mr. Greer?
Nothing else. Thank you, Your Honor.
You're free to go, Ms. Collins. Thank you. You may go or stay as you wish.
Thank you, ma'am.
Call your next witness, please.
Lieutenant Darren Nuts. hand for me. Swear affirm testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. Can you state your name for the record, please?
Lieutenant Darren Meadows,
And you're a lieutenant. Where are you a lieutenant?
Houston County Sheriff's Office.
How long have you been with the sheriff's office?
37 years.
It kind of dawned on me that we get ranks of people who come up here and don't really explain what they are. What's a lieutenant?
Well, in my office, I'm the assistant division commander. So that means I'm like the number, there's a captain, and then I'm the lieutenant. And then we both have similar duties in that we manage the investigators in our office and some other related duties.
And is that for the juvenile division?
Yes, that's for the juvenile division of the sheriff's office.
And what is the role of the juvenile division of the sheriff's office?
We have two main roles. One is to investigate child abuse-related incidents involving children under the age of 18, and also juvenile crime-related issues for children who go out and commit crimes.
Were you working in that capacity in November of 2020?
Yes.
And have you been working in that capacity since November of 2020?
Yes, sir, I am.
I assume you were working in that capacity before that, those days as well?
Yes.
Okay. And as lieutenant, did you become aware of an investigation into the death of Carter Ambrose around that time?
I did.
Okay. And who was the investigator who was on call?
Sergeant Keith Collins.
And he's the one who just testified, right?
Yes.
And so he would be the person leading up the investigation, right?
That's correct.
Okay. And would you have any involvement in his investigation?
Possibly, it depends on the case. I have 7 investigators that work for me, so they're all working cases at any given time. So they usually keep me updated on the status of what's going on in their investigations.
Okay. And at some point while the Carter Ambrose murder was under investigation,
If you don't, please, let me just, that's for this jury to decide. I mean, I just object to it being characterized as being a murder.
Well, that's the objections overruled, that is the prosecution's characterization, and they can ask that. Obviously, that will be the question the jury has to decide is, so go ahead.
Did Sergeant Collins leave at some point?
He is.
Okay. And then you became involved?
I did.
Okay. And how did that come about?
Well, it was just kind of the natural evolution of the case. By the time, I think he left 3 or 4 months after the death of the child, and he had done most of the investigation. Up to that point, he had completed everything that was available to be completed.
Okay.
We were waiting on the medical examiner's report, so I was just kind of monitoring the case at that point just to make sure there wasn't anything else that was needed or something else that the district attorney's office felt like we needed to do or review. So I was just trying to kind of monitor what was going on with it up until the time the case was complete.
Okay. And it took a while to get the autopsy report, the finalized version, correct?
It did.
And prior to receiving the finalized autopsy report, was there some kind of meeting with certain people involved with GBI in your office?
Yes, we had a Zoom meeting with myself, I believe it was Eric Edwards with the DA's office, and then the 2 of the medical examiners from the GBI.
There's Daniel Brown, the medical examiner,
Correct.
and then Jonathan Isaac sat at the time was the chief medical examiner.
Yes, sir. Yes, sir.
And you said members of the DA's office.
Yeah, that was on September 27th of 2021.
And from your recollection, what was the purpose of that meeting?
To understand exactly, to discuss what the final outcome was of the medical examiner's autopsy, and to kind of nail down like time frames, what exactly happened, what was the report going to be, when were we going to get the report. We had communicated with them over and over again about needing the report, and it was trying to get all the complete information for the case.
Right, and at that meeting, I think a time frame for when the injury could have happened was discussed as well, right?
Yes.
And then after that meeting, at what point was the autopsy report received?
I received it on November 12th, 21.
And after that, up to this point, had you interviewed anybody involved in the case?
Yes.
I mean, you had this meeting with people who were involved in the case, but the witnesses and stuff, I think you said Sergeant Collins had kind of completed all that.
It had all been completed months earlier. We were just waiting on the additional information to complete the case file and investigation.
Did you reach out to the defendant after that meeting?
Yes, after I received the final autopsy report from the GBI. I reached out to Kianna Davis, the defendant, and asked if she would like to come in to discuss it. We got received the final report, and she'd like to come in to discuss the report.
Okay, you said you called her?
I did.
Okay, do you remember, did she agree to come down and talk with you?
She did.
Okay, do you remember when that conversation took place?
She came to my office on December 9th of 2021.
Okay. And when you said she came, do you know how she got there?
I do not know. She just showed up at my office.
Was she a suspect?
I think so, yes, sir.
Okay, she was a suspect.
Yeah, she was the mother of the child with the child.
Okay. In order to get her to come down or to drive to juvenile or however she got there and speak with you, did you offer her any like hope, benefit, or promises?
No,
Did you threaten or coerce her in any way?
no, sir.
Was she in custody at the time?
She was not.
Did you arrest her at all that day?
I did not.
Did you read her Miranda?
I did not,
Why not?
because she was not in custody. It was not an in-custody statement. She was free to go.
I'm sorry. Let me cut you off. And after you guys spoke, did she leave?
She did.
Okay. And this interview, was it recorded?
It was.
Have you reviewed it?
I have.
Is it a fair and accurate representation of the interview?
It is.
Has it been changed or altered in any way?
It has not been on
Your
board.
Honor, this is State's Exhibit 63, which I will offer in evidence now.
It's admitted.
Over objection, Your Honor.
Noted.
All right. Before I continue on, where is this?
This is at my office, the
Okay.
juvenile division of the sheriff's office.
This is your interview room?
It is.
And is that Ms. Davis?
Yes.
How's the drive down?
Long. Yes,
I ain't
traffic.
talking about that.
It's so much traffic, and then they're working on the road still, of course, so.
Sure.
Lanes are closed everywhere.
It's almost, I go like North Georgia, I said last week, that October was through Atlanta, 75 to 675, 85.
Yeah.
No. You're just rolling the dice
Yes.
every time you get over there. So, let me just get a little current information on your page, your home address.
302 RCARD SLEY Place, that's Northwest Georgia, 393. And it's apartment 302.
What was it?
393.
All right, and your phone number's the same?
Yes.
What's that?
478-302-3335.
3335? And, no, Ross, is that North Atlanta?
It is.
Okay. And where are you working at this?
Peachtree High School in Gwinnett County.
Peachtree? what?
Ridge.
What do you do there?
A teacher of computer science.
Oh, cool. All right. And, let's see. Now, Mr. Benton, are y'all still together? No? Do you know where he's currently residing?
I don't, but I'm pretty sure he's in the same spot.
Somewhere in the Atlanta area? Okay. That's what I thought. I'm just trying to make sure I have updated information. So, I don't know if you knew or not, but Sergeant Collins, who originally investigated the death of your child, was he's on with the department. So the case has been just kind of, he had done almost the entire investigation, but at some point we've just been waiting on medical examiner report, which for some reason took an extraordinarily long amount of time. I don't know, I've never had one take this long, so that's why I contacted you to let you know kind of it was finished. We had some discussion about the case and where we go from here, and I just kind of wanted to bring in further that. And I think y'all already used some of this because Sergeant Collins had told you, but until we actually get an official report from the medical examiner for the GDI, then that's what we have to go by. So I'll just go through and read some of this to you. Now this part is from, let's see.
is GI. So they've sent this report to the coroner, which is Danny Galvin, in reference to Carter. This was a full autopsy done. The immediate cause of death was blood impact injuries of the abdomen with a laceration of the liver. They deemed the manner of death to be a homicide. And injuries would have occurred by the child receiving blunt impact trauma to the abdomen. Okay, and that was signed off in September of this year. And they got a lot of just report stuff. This is some of it's just medical terminology and stuff, weights and different things. And, let's see if I can get that here. Under the opinion, this is the opinion of the medical examiner who performed the autopsy. I'll read it. It says, this 2-year, 10-month-old black male child, Carter Ambrose, died of blunt impact injuries to his abdomen. Carter was the last known alive on Tuesday, November 17, 2020, at approximately 30 hours. The mother reports that the child had thrown up in his bed around 0200 and told his mother that his stomach had hurt. The mother left the child in the care of her boyfriend at approximately 7:15. The boyfriend called the mother at approximately 8:30 and said that Carter was having trouble breathing and going in and out of consciousness. He had given the child a breathing treatment, but it didn't work. The mother said to take Carter to his pediatrician, which was located nearby. Upon arrival, he was unresponsive, and the doctor administered CPR, and the nurses called for EMS. This then was transported to the hospital, where resuscitative measures continued but unsuccessful. Further information is contained in their in the report. The autopsy revealed blunt impact injuries of the head and torso, most significant visual multiple contusions of the abdomen, and a liver laceration, which resulted in bleeding into the soft tissue and abdominal cavity. Based on the information known, the manner of death is classified as a homicide. If any, so the cause of death. So that's kind of
Which I know, we've been in contact with the coroner.
okay.
My question would be, the blunt force, was that from CPR?
No, because that's why he went into distress. His abdomen was full of blood, and even if if you had a layperson that's pushing someone's chest, these were doctors and nurses that, I think the doctor himself was performing the CPR. Mm-hmm. So you have a medical professional who's doing that. But no.
There's just no way. There's really just no way. Because my son has been multiple places before his passing. All of which he showed no sign of hurting, no sign of anything until a literal, my stomach hurts. And that's the last thing. And it wasn't even, my stomach hurts and he's in pain. It was, Mommy, my stomach hurts.
But then you started having the stomach pain and the vomiting started happening Sunday night too.
Correct. No, Sunday night is when I asked him. He looked like he wasn't feeling well.
Okay.
Which that wasn't something that it was dramatic because of the time of year is when he normally has breathing issues, and that's what to me it seemed like he was just not feeling well, not anything.
But on Sunday night he did complain of stomach hurting. And then continued through Monday, off and on, was vomiting some, correct?
Monday was when I was at work in Warner Robins.
Right.
I literally went home, and he was asleep on the couch. That's when I saw throw up on the floor. At the time, I didn't know it was throw up because it just looked like his juice that he had been drinking.
But now, if he was that carpet or what?
Carpet. It's orange juice.
Kianna?
Mm-hmm.
Did he have not seen that?
Yes, he was sleeping on the couch. I don't know if he saw it on the floor or whatever, but me.
I just know if my wife came home, when my kids were throwing on the floor and they cleaned it up, I'd be like, in trouble, kind of thing.
I came in. He's on the couch sleeping. I go over to check on him, kiss him, just to see if he's fine. I look over. I see blood on the floor. Well, from what I suspected, juice.
Yeah.
immediate thought is, he threw his cup.
And Jesus went everywhere, but then you later figured out it was,
Later, as in, when I went back to work and I came back home, there was also juice on the couch, which then I said, I then cooked dinner. I also bathed him. In the bath was when I was washing his butt, and he was complaining about his bottom area hurting.
like his butt or like his
Like
stomach
his,
or lower abdominal?
yes,
Okay.
well, really his balls.
Okay.
And he had done that a week before. But I didn't make anything about it because he's dramatic. Carla, he's a mommy's boy. So I said, okay, I'm going to see if he complains about this again. Nothing else. The next thing I know was the day that he passed away. That night before, I had put him in bed because of the stomach hurting. He had ate, we watched a movie, he danced, literally nothing. Until I went back in the room and I checked on him that night. And I saw that he had threw up in the bed. That was the first alarming thing to me.
Right.
Nothing else throughout the entire day, even when I got back home. Nothing else would even tell you that the child was in pain. He was not acting any kind of way, which is why it was such a, if his stomach had been hurting to the point where he would make any kind of movement to let me know that he was in that much pain, I lived next door to the
Well, and realistically, I don't know, I'm not an expert on those kind of injuries. I've been working in this office for almost 30 years, so I've seen a lot of stuff and, had a lot of investigations. I don't know how much pain he would have been in. If there was some impact to his abdomen that caused a liver to start bleeding, it could have just been slowly bleeding. I would know that, maybe that's something that just over time got worse, and eventually that's what happened. He got to the point where, he was unconscious.
And that's what is so confusing about this entire thing.
But now, when we talk to the medical examiners, and they're giving us a window of, 24, 48 hours when the injury could have occurred. So we're looking at something in a time frame, and realistically, I know from looking back at Sergeant Collins' report that, I know you picked him up from daycare on Friday, so that's, we're talking almost 4 days earlier. You got, you went to the grandfather's on Saturday for a few hours, right?
Basically the whole day, because I went over there and I cooked for my grandfather, and Carter was in the bed sleeping.
But he was with you that whole time, correct?
Correct, he was right there with
Right
me.
with you. So then we have Sunday, which is all day with you, and then later that afternoon, Kianna, is that how you said it?
Kianna came down.
Later this afternoon around 5, and then he was there at night, and was there all day Monday. Now, it's my understanding that you contacted the child's father on Monday and asked him to watch him because he was sick.
Because he was not feeling well.
Right.
Correct.
He was sick,
And I had to go to
and
work.
apparently he was unable to. So I guess that's why Kianna just stayed over.
Yes, it is.
Okay. So.
And the reason being is because my child's father is a firefighter. So I knew, number one, we are very familiar with Carter around that time of year, having issues. And number two, if he could be with anybody, I wouldn't leave him with someone that's not me or him, or someone close to him.
Yeah, I understand.
So that's why none of this makes sense. I know for a fact it didn't happen within the last Friday, Saturday, Sunday, or Monday before, or the Monday before he passed.
Well, you don't know if you're not there. So when you're working, you're not there. You can't say something didn't happen. And I know from reading the other stuff that you think Kianna has nothing to do with this. And again, I don't know. I'm just doing the follow-up on this, okay? And I'm not here to rehash the whole case. Y'all already discussed it in other sessions. But me as someone who's seen a lot of these cases, not necessarily this particular kind, but in general, I guess my question, on your end would have been, as the mom, why did you wait so long if he was sick and you were used to taking him to the doctor, if he'd been complaining like for a day and a half about, blowing off by the stomach and throwing up at least 4 times?
Here's why. Because Carter is used to, for whatever reason, when he was first born, he would throw up from milk.
Okay.
He's had multiple situations where he'll throw up.
But that's not unusual for children who are on formula to throw up.
Correct.
I mean, that's.
However, Carter also would have random reactions to foods, anything, and every time I take him to the doctor, they just throw him on a steroid, send us on our way. So the stomach ache, if it would have gotten over to a 24-hour period to where he was actually complaining and still complaining about it, yes, I would have taken him to the doctor. But that's the reason why this doesn't make sense to me, that it couldn't have happened in that time frame. Because
Well, but then my question to you is that if on Sunday night was his first time he was really complaining, saying he was hurting, and now Tuesday morning, you woke up in the middle of the night, early morning, and he's thrown up again, and you put him in the bed.
well, that's my reason for calling it that.
But that was, you called him Monday, right?
Correct.
Okay, but
Sunday night
but
and Monday morning.
But you said something to the effect of it had been more than 24 hours, but it had been more than 24 hours.
Sunday was the first time that he had ever said anything, or not even really say anything, but started to act as if he was not himself.
Okay. And I get that, but we're Tuesday morning, you leave for work,
Correct.
so we're
Tuesday morning.
we're over a day. You go from Sunday night, Monday night, now we're Tuesday morning, and you know he's still sick, and y'all give me breathing treatments, and
We gave him one breathing.
the one treatment, which I think that was when he was toward the end, and then of course he had to rush him to the pediatrician's office at that point. But,
Correct.
I'm just asking, was there? Did you just not think he was that sick, or
A stomach ache is not alarming to me, which is why my initial thought was check his breathing, because that's his normal issues.
But he never had problems with the breathing.
We've been at NICU 3 times.
No, I'm talking about during this time.
During this time, I did not know. That's just my first immediate, let me check his breathing because of the time of year number 1 and because of his history. He's continuously in the doctor's office for breathing issues. So that was my first thought. With a stomach ache, he's had multiple stomach aches before. So that's why I'm saying, if it was something to where he was crouching over or can't walk or not running around laughing and smiling, of course I would have taken him to the doctor. I go there more times than not. I'm sure they'll tell you. However, it wasn't that. It was literally, Mommy, my stomach hurts, and laying on me. Do you want to go to bed? Mm-hmm. Okay, let's go lay down. That's it. And so for me, that's where my pain is, because I have no idea what could have happened to my child and when it could have happened.
Do you think now, looking back, if you had maybe had taken him Monday or taken him to the ER, that and he was bleeding internally, that maybe something could have been found on that?
I don't know. And here's why. Because any other time I take him to the doctor for the breathing, we'd be brushed off. Send him a steroid, send him home. We've been to a pulmonologist. Oh, he
But
doesn't
this
look
isn't
like-
breathing, this is abdominal pain thrown up.
This is a stomach ache to me, not abdominal pain. This
Well, okay, well, it's hard to qualify, but I understand what you're saying. Yeah.
If he came to me and said, and was crying, or acting as if he's just literally, from what you're telling me, he should be in the most pain.
Again, I don't know how that reflects.
He's 2.
But if, and I'm just giving you a scenario, I have no idea. If you leave for work at Monday at 7 o'clock, and at 9 o'clock something happens, and 3 hours later you come home for lunch,
And he's asleep.
and he's asleep, and
Well, that's,
maybe he's not in pain, maybe he was, there was some injury there, and he bled, and then continued to bleed until, Tuesday. But, there's no way the internal organ can get lacerated.
definitely.
Right, it just can't happen.
So,
Does this change any concerns you have
I know
about Kianna?
Kianna as a person. I know who he is, and I know how he is with kids, and especially with my child. He's in the process of trying to get us to his own.
I understand that, but
So,
sometimes good people make mistakes and do bad things.
sure.
I mean, it does happen.
Sure.
And I will tell you, it's from my experience, that when you have a child that's going through potty training issues, they're kind of in that transition where sometimes they have an accident or they do that. I think there was some discussion about he peed on himself some, and a few times during this issue, through this investigation, that sometimes those people get frustrated and that can make them act out angrily toward a child during a potty training.
Other than to,
I'm not saying you did.
no.
I'm just saying that somebody else could.
I understand what you're saying, and if that's the case, then do whatever you need to do. I don't care. Because at the end of the day, I know for a fact that in my care, nothing happened to my child. I know for a fact that when I got home, my child was not acting as if anything had happened to him or if anybody beat him up. And in my mind, because of the relationship that I have with my child and because of previous incidents where even if a child hit him or if someone told him something that he didn't want to do, he'd run to me and immediately tell me.
Let me ask you this. If Carter had been with his dad that weekend, only his dad, no one else, no girlfriend, no grandparents' house, he stayed with his dad all weekend and then had passed just like he did on Tuesday morning. And they come back with this report that says blunt force trauma, lacerated liver, bled internally. What would you think then? Would you say just because he's a good person he couldn't have done it?
I have the same questions because of who he is as a person.
Right.
I don't know. I can't speak on who people are if I have never seen them in that way.
Sure.
So no, I would not have felt any differently about this situation.
So you think,
because I know
so your feelings are based on the fact that
of how I know the person.
the person, okay. And I assume how you've seen him interact with
How
your
I've
child.
seen them interact with my child. Neither one of them.
But you do understand that that in and of itself is not enough to clear a person
Oh,
up.
of course.
Because if we say Kianna didn't have any part in this, then the only person is you. And you're saying adamantly you didn't do it.
Let's be clear. There is no way in the world that I would hurt my child, and I work with kids all day. That's me. So
But you're
I don't care.
saying if Kianna did this, he should be punished.
Yeah, that's not even a question.
So,
I don't care.
but I guess I'm a little confused from the standpoint of if you were the only person there,
If I was the only person,
then we would all be talking to you. But since you know there was only one other person that was there, how can
it's
you?
hard for me to come to a conclusion about someone that I've never seen. That to me that's like false accusations. I don't want to be a part of that. If he did it, hold him accountable. Do whatever you gotta do. I don't care. It's my child. At this point, it's me and my child against everybody else. I don't care. But what I'm saying is that what I know is what I said. And if he knows anything, and if he feels if he didn't reveal everything, I don't know. But at the end of the day, I don't care. Because I just want to know what happened to my son, who did it, and I want that person held responsible. But I know for a doggone fact it didn't happen in my care.
Okay.
So,
Well,
I
I guess what we're looking at as far as the case goes, and ultimately, the district attorney's office makes the decision on who's charged and how they're charged. But you know, if he's charged with a crime of murder or involuntary manslaughter or something like that, you know, that'll be something that the DA decides. But you have to understand also, as a parent and as a caretaker, you bear some responsibility in the fact that you are the parent who's supposed to care for him, and you he was sick, and he didn't get medical treatment or get checked, and therefore wound up dying as well. So there are.
when you say sick, it annoys me because it's
Injury?
almost as if
I mean,
I wouldn't have taken those steps.
I understand. And you know what? Hindsight's 20/20. We can all look back and say we should have done something different, or maybe you say you should.
I shouldn't have, because I would have done the exact same thing because it literally, this child sang, danced, smiled, laughed, everything with me that night before. So for me, my immediate thought, because I know my child, I'll be looking for all the signs.
Okay. Well, what I'm telling you is, from a legal standpoint, if the child had some presentment of some type of issue or problem that could have resulted in him getting medical treatment and that was not done or being checked, then you could also have an issue of legal responsibility as well.
So would you take your child to the hospital when they ask you for a stomach ache? Or said they had stomach ache? Would that be your first?
Well, it wasn't the first time. I'm not saying it's Sunday night just because he says he's has some issues or throws up that you immediately have to go. But you got Sunday, you got Monday, you got Monday night, you got Tuesday morning. So,
Tuesday morning, nothing was going on with him. Tuesday morning,
when you said you woke up and he had vomited all over himself,
that was in the middle of the night.
but when I say Tuesday morning, I was told it was about 2 o'clock in the morning, so.
When I went to check on him, he had thrown up in the bed. Before I picked him up.
But, and I don't want to get argumentative with you, but I'm just trying to explain to you where we're at, where we're at legally, okay? That you could bear some legal responsibility from the fact that he wasn't given care and he obviously passed from the injuries he had, that appeared to be during that time, he had sustained injuries. Okay? So I don't know that will happen, but that's certainly something.
He certainly won't. That's why I have an attorney.
Well,
So,
the
at this
attorney
point,
can't keep you from
from
getting charged with a crime.
But what I'm telling you is don't. Now you're irritating me.
I'm sorry, I don't get irritated.
Because at this point, it's almost as if, and it has been almost as if I'm a bad mother. And no one has asked about my reputation as a mother, as a teacher, as someone who's literally mentored kids since I was in 12th grade with this police department. So I don't care.
When I read through the report, they didn't ask about you.
Oh, okay. And I don't care. At the end of the day, everyone around me knows I would do anything for my child. I would protect my child from my own family. If anyone did anything that I did not like, for instance, when my mother herself did not take his breathing issues as if it was a serious thing, she no longer got to watch him. So at this point, that's what I'm trying to tell you. If any indication, he would have been removed.
Well, I believe you on that. I'm not saying you.
As a single mom, what was I supposed to do when I asked his father to get him and take care of him?
I don't know. I'll let you take off work. That's what I think.
And that's my point. Because that whole week, I was already supposed to be home. It's the end of towards holiday. You only get a certain amount of days. I was actually in the middle of switching jobs. So I was already done that rest of the week, which is why I didn't take off and which is why I offered or asked his father to get him for that day because I was going to be off the rest of the week anyway. So, with that being said, I did everything I knew how to do and what to do. As far as this investigation goes, I don't care what you do with Kianna. But that seems like we need to be talking to. Because at the end of the day, I walked in my house, I saw throw on my, or juice on my floor, whatever it was, and I immediately thought, this is weird. But it didn't strike me to be like, oh my God, let me take my son to the hospital. I've been through many situations where he almost did not make it because of his breathing. So I know that it's serious with my child. And I know how my child acts when it's serious.
But apparently this time you were wrong. Right?
Weird.
Your son passed away.
My son passed away, yes.
Apparently the wrong decision was made at some point.
Ooh, Jesus.
Well, do you have any questions?
Nope.
Okay. Well,
I haven't seen a copy of everything that you guys saw, the medical reports I've been sending.
I can't give you anything because it's still an ongoing investigation. At some point when that's closed, then you can get a copy of whatever you need.
So can my attorney request it?
He requested it, he can't have it. Until the investigation is closed. All right?
That video, that's very accurate. Remembering the actual interview that you did with her.
It is.
Is that the extent of your involvement in this case, other than the fact that you're here today?
I completed a report based on that interview, and then I forwarded that along with video to the district attorney's office to complete the case file.
Did you handle any evidence in this case?
Other than the video and the report I heard. No, sir.
That you weren't out at the scene?
No, sir, I wasn't involved in the scene or the actual investigation.
You know where she was living at the time?
Apartment complex in Warren.
In Warren Ross? You know if it was in Houston County?
It is.
Alright. Do you see Kianna Davis in court today?
Right there.
What's she wearing?
White shirt.
He's identified that for purposes of the record. Nothing further at this time, Your Honor.
Mr. Grove, your questions for Lieutenant Bennett?
Thank you, Honor. Lieutenant Bennett, good to see you again.
Yes, sir.
We go back a long way, do we not?
We do, sir.
I'm not going to be very long with you, but ask you a few things. This incident occurred on or about November the 17th of 2020, is that correct?
Yes, sir.
And at that time, you were the lieutenant that was in charge of all of the investigators, is that correct?
That's correct.
And the on-call investigator was Sergeant Pete Collins, is that correct?
Yes, sir.
Once again, you didn't go to the scene there on Lakeview Road, did you?
No, sir.
Did you? When the investigation that the sergeant did on this case included, did it not, a gathering of possible evidence from the scene, is that right?
I believe there was some items gathered from the scene.
Okay. But you answered Mr. Joyne's question, and I don't want to belabor the point, but the evidence was taken by Investigator Herrera with the Warren Isles Police Department. Is that correct? That you know of?
That's my understanding.
And protocol would be for the Warren Isles Police Department to hold that evidence until such time it was needed either by somebody that can analyze it. Is that right?
Assuming it was something that needed to be analyzed, yes.
Were you made aware that there was evidence collected at the scene that should be analyzed?
Yes, sir.
In information provided to you, being the supervisor by Sergeant Collins, did he ever inform you that the Warren Isles Police Department had taken photographs and had collected possible evidence that could be used in this case?
I don't think we had a specific discussion about what was photographed or what was taken. I knew that Warren Isles had processed a crime scene, which is very common when we work cases within their jurisdiction. And they always photograph and take anything, take evidence, whether that's their doing or directed by us. I wasn't aware of that specifically.
But once again, 3 months or so later, Sergeant Collins left the sheriff's office, and that left the case in whose lap?
Left it what, sir?
Who's the case left with?
It was left with me.
Okay.
Well, as I testified, it was mostly completed from that point. In May of 21, after he left, it was requested that we send the case file to the medical examiner's office, a copy of it, and we did that. So they knew what was there, what was collected. If they had wanted to examine something or test something further, they certainly could have requested that. We would have seen it.
Were you aware that soon after the child died, that toxicology reports were done on the child as far as, were you aware of that? That there were toxicology reports that were done and completed by the GBI and turned over to law enforcement?
The only thing I was aware of was the final report that we got in late 21. They did a separate toxicology that was sent in. I'm not familiar with that.
Would reports of that nature be necessary in order for there to be an autopsy report?
That's usually part of the autopsy. We wait on that. Generally, that's one of the things that we have to wait on is the toxicology and things for them to include that in the final report.
But once again, the sergeant leaves, you take over the case in February of 2021, right?
Yes, I'm basically monitoring the case at that point.
Okay, by monitoring, what do you do?
I'm not doing anything on a day-to-day basis. The case, as I said, was already investigated. We were waiting on the final autopsy report to find out exactly what caused the death and everything, so we could proceed with the investigation.
So the autopsy report was done after you had this Zoom meeting with Dr. Eisenstadt and Dr. Brown and Eric Edwards of the district attorney's office and other people that worked in their office. Is that right? That was in September?
Yes.
All right. And within a couple of days, the report was generated.
I don't know when it was generated, so I guess there's a date on it, but it was given to me on November 12th.
All right. If the report, you have a copy of the report with you?
I do.
The report reflected it was actually signed off on by Dr. Brown and provided or completed on September the 29th of 2021. Yes, last page shows it. In the meantime, up until this time, had you ever talked to Ms. Davis?
No,
Do you know if she had ever called your office?
I'm not aware. I assume she talked to Sergeant Collins, but I have never talked to her.
Okay. Do you know as well not anyone in your office ever talked with Ms. Davis from the time that Sergeant Collins left until you had this Zoom meeting in September of 2021?
Not that I'm aware of.
But in any event, you get the report. The report's provided to you in November, basically the middle of November of 2021. Is that right?
Correct.
And you took it upon yourself to contact Ms. Davis to see if she could come in with you.
Yes.
And she came right on down.
Yeah, about a week later.
I mean, there wasn't any real delay.
About a week later.
All right. And the first time I guess she met her was when she sat down at the table with you?
Which is on video, yes, sir. That's been my only contact other than phone call.
All right. And when she met with you, she told you that she had in fact moved, she had taken a job, she had left this area and taken a job up at Peachtree Ridge High School in Gwinnett County. Is that right?
Yes, sir.
Did you check on that?
To verify she was employed as a
Right.
teacher. No, sir.
Objection on relevance, Judge.
All right, I'll move on. But in any event, based on your reading of the autopsy report, you, at that point in time, you considered her a suspect, did you not?
Yes.
And once again, you did not advise of any Miranda rights. Is that right?
That's correct.
Did she come with an attorney?
She did not.
She mentioned during the conversation that she had an attorney, did she not?
She didn't say she had one. She asked if she needed to bring one, and I told her she could bring one anytime she wanted.
But
She said she did not wish to bring an attorney.
Okay, but at the end of her conversation, she mentioned that she had an attorney. Is that
Oh, you're talking
right?
about the video?
Right.
Oh, yes. When I mentioned that she could possibly be charged, she said, well, I have an attorney. And I think my response was something like, well, an attorney can't keep you from being charged with a crime.
But she asked you, did she not, if she could have a copy of the autopsy report,
She did.
and you would give it to her?
No, sir.
Why?
Because we don't give out copies of our case file until the case is completed.
So, I mean,
And I told her that after once it's completed, she was welcome to have a copy.
okay. But you also said that she asked if her attorney could get it, because you didn't think that they would give it to the
We
attorney.
wouldn't give it, now they could get it to the DA's office during discovery. She could request it from the coroner's office if she wanted to.
Now, this was, once again, this conversation that you had with her, is that the last time that you talked to her?
It is.
And that was, once again, December the 9th of 2021, correct?
Yes, sir.
And she was free to leave after that.
She was free to leave and she did leave.
And at any point in time, did you ever arrest her?
I did not.
Did you ever take warrants?
I did not.
You presented to the district attorney's office for them to consider this, is that right?
It was, the agreement, discussion with the DA's office was that once we completed everything, it would be turned over to their office. They would review everything and then it would be presented to the grand jury for an indictment.
And when this matter was presented to the grand jury, it was when?
I couldn't tell you, sir, I wasn't involved in it.
About 2 years later, is that fair statement?
I would assume, but again, I wasn't there.
Okay. You weren't the
Objection, Your Honor, on relevance.
Objections overruled. It is already in evidence, however, that this case was presented to the grand jury in October of 2023. Moving on.
all right. But you didn't present this case to the grand jury.
I did not know.
During the period of time between when you had this meeting with Ms. Davis and the time that it was indicted, did you continue to work on the case?
There wasn't anything for us to work on after I completed writing it up and I turned over my case file. I continued to have communication with the DA's office about the grand jury, when this case was being presented. So that was my only follow-up, was inquiring about that.
And you never had any other occasion to talk to Ms. Davis about this matter?
I did not.
Just a second, John.
Yep.
hour and 45 minutes, so we're gonna take it, I mean, well, a little longer than that, actually. Anyhow, we'll do for break. Don't talk about the case, don't let anybody talk about the case with you. Take about 15 minutes, you know, to excuse the jury room. How many more you got, Mr.?
Send the rest.
Okay. All right, so if you're gonna do that after the break, Mr. Greer, do you have evidence you want to present?
Judge, if I may talk to my client during the break,
Yep.
if she was going to say something.
Okay. I'm gonna print, I don't care, it coming along. Maybe I'm gonna go to my office and print a copy of the charge that I have thus far, so that when we're talking, y'all can follow along. And then, we'll see where we're at, okay?
Yes, ma'am.
All right, let's take 15 minutes and then we'll reconvene and see what we're doing next. Let me close this.
directed verdict making.
Mr. Greer, are you going to have evidence to present?
Yes, we will. Ms. Davis is going to testify. I'll tell the court that, when the state is, if the state is arrested, that's fine, but I'm going to have a motion for directed verdict making. I don't necessarily need to make it now, but as long as it's timely in the court's mind, I can make it whenever the court wants.
Well, you're going to rest immediately when I bring it back in.
Yes.
Let's go ahead and hear your motion for directed verdict,
Okay.
and then I'll let Mr. Dwayne officially rest on the record in front of the jury. So since we're already out, let's do that. Go ahead.
If you want to please, for the record, insofar as the state has arrested, the defense will make a motion for directed verdict of acquittal as to all counts. Specifically, I'm not going to belabor each count, but I am going to mention that, of course, the court's well aware of the legal standards that are required of the state in order for a case to, at the conclusion of their evidence, to get to the jury. And I would argue to the court that count one being malice murder, the state has not met its burden in this case. They showed no malice aforethought in this matter. They found they presented no evidence at all as to the allegation of malice aforethought, and also their allegation of beating the child with an object that would cause death. As to count two and three actually go together. Count two being felony murder, being with the predicate offense being count three of cruelty to children in the first degree. We would argue to the court that the state has failed in its burden to prove any of the allegations in counts three and two, with three being the predicate offense for felony murder. We would just argue to the court that the state has failed in its burden in this case, should not go, or these two charges should not go to the jury. Counts 4 and 5 are felony murder and aggravated assault, and basically the same principle that I've argued previously as to counts 2 and 3, we would argue to the court that the state has failed in its burden. Counts 6 and 7 also are tied together, if you're going to please, and as we've mentioned, we don't often see in this court a charge of murder in the second degree. In the murder in the second degree, which is I guess I would consider a lesser, even though it's a murder charge, it's a lesser
Penalty.
type case. It's a lesser punishment, for example, for a case like this, but it's also based on the predicate offense of cruelty to children in the second degree. And the burden is on the government, of course, to prove that Ms. Davis, in her actions, committed criminal negligence, which would rise to a level of cruelty to children in the second degree, and therefore become part of murder in the second degree. And we just feel as though the state has failed in its burden, and that would ask the court to dismiss all the charges against Ms. Davis.
Mr. Dwayne?
Your Honor, as to counts 2, 3, 4, 5, they're essentially malice murder without the malice part of it. There is sufficient evidence that was presented based on the method and manner of death that the child was killed intentionally. There's evidence that the injuries occurred while the child was in the custody of this defendant and co-defendant, or both of them at the same time. There is sufficient evidence based on what the medical examiners have testified to, in addition to, obviously, the primary pediatrics people, that there was a death and that it was intentionally caused by another. Counts 6 and 7, those are based on criminal negligence. I mean, there's clearly evidence that she knew or should have known that something was wrong with the child and taken him, or should have taken him to get him looked at. I think they're all jury questions at this point as to whether or not they agree with the state's theory.
All right. With regard to the malice murder particularly, malice can be found when there's no significant provocation and all the circumstances of the killing show an abandoned and malignant heart. Certainly the nature of these injuries and the relationship of this defendant to the parties, a jury could find by circumstantial evidence that was the case here. This is a circumstantial evidence case, and I do think the state has presented sufficient evidence on each of these counts, although it is certainly circumstantial, to get the question to a jury. So the motion for directed verdict is denied as to all counts. All right, let's bring the jury in. Ladies and gentlemen, I appreciate your patience. Sometimes there are things at certain junctures in the trial that we have to take up outside your presence. We did that while you were on your break today. Mr. Dwayne?
No, at this time, the state will rest.
All right. Mr. Groove, do you have evidence that you wish to present?
Yes, Your Honor, we would call the defendant to the stand.
All right. Come on up, Ms. Davis. Have a seat and witness stand, please.
Ms. Davis, let me have you up to your raise your right hand, please. You solemnly swear or affirm the testimony you give in this honorable court to be the truth, the whole truth, and nothing but the truth, so help you God, so say I do. Okay, Ms. Davis, I need for you to speak slowly and loudly so the court reporter can take down all the testimony and the jury, of course, can hear you as well as the judge. Ms. Davis, you are the defendant in this action, are you not? And do you understand that you're under indictment of these 7 charges that have been presented here to this jury during this week? Is that correct?
Correct.
Do you understand, Ms. Davis, that you are under no obligation to testify?
Correct.
That if you should decide to not testify, then this jury cannot infer or think anything harmful towards you because of your silence. You understand that? Do you also understand that if you should decide not to testify, that the district attorney's office could not argue to the jury that you're holding something back? And that if you do give testimony, then you'll be subject to cross-examination by the district attorney's office. Knowing that, do you wish to testify here today?
I do.
All right.
Yeah, speak up for me, okay, Ms. Davis?
Ms. Davis, just make sure that we have your complete full name. Tell us that, please.
Kianna Davis,
What is your middle name?
Aisha Renee,
And tell me the date that you were born,
December 12th, 1990,
and where were you born at?
in Myrtle Beach, South Carolina.
Ms. Davis, are you a high school graduate?
I am.
Where'd you graduate from and when?
Warner Robins High School in 2009.
Have you lived in Warner Robins most of your life?
Warner Robins in South Carolina is
Are you married? Have you ever been married?
No,
Did you give birth to any children?
I did.
And who was that child?
Carter,
What day was Carter born?
January 14th, 2018,
And where was he born at?
in Macon, Georgia.
And when did Carter pass away?
He passed away November 17th of 2020.
Who's the father of Carter?
Canadian Ambrose.
Let me ask you this, Ms. Davis. Were you and Mr. Ambrose, Kadeem Ambrose, were you living with each other at the time that Carter was conceived?
At the time that he was conceived, no, but when I found out I was pregnant, yes.
Okay. And where were you living at that time?
At the time that he was conceived,
Right.
I believe I was back at my grandfather's house,
And who was your grandfather?
James Kennedy.
And Mr. Kennedy testified yesterday, is that right?
He did.
And what is his address?
309 Bonnie Drive, Warner Robins, Georgia.
And is that off Russell Parkway?
It is.
Is that where you're living at now?
It is currently.
So at some point in time, you were with child, is that correct?
Yes.
And Kadeem Ambrose was the father of that child, is that right?
That's correct.
At some point in time, did you and he move in together?
We did.
When would that have been? Approximately.
Approximately, maybe immediately after I found out I was pregnant, or maybe like a month or two afterwards.
And where did you move in with Mr. Ambrose?
We moved to Sandpiper Apartments.
And that's in Warner Robins, is that
That
correct?
is correct.
Is that off Russell Parkway?
That is correct.
So at this apartment, until the baby was born, it was just you and he?
Correct.
Where was he working at?
He was a firefighter for the firefighter.
And he testified, did he not, yesterday?
Correct.
And at that time, where were you employed at?
I believe I was working at FedEx at the time, but then I switched jobs to a dermatology office
Where was this dermatology office at?
in Maine.
And this was while you were pregnant with Carter, is that correct?
Correct.
Were you in college at the time?
I believe I was taking some extra classes. I had already gotten one degree, but I was getting certified for a specific programming language.
Okay, where did you get your bachelor's degree from?
Mercer University.
Out of Macon?
Yes.
And what was that degree in?
Software application development and human-computer interaction.
And you say that you were taking some extra classes at that time, is that right?
I was taking, this was before going to Mercer, I was taking extra, I had already had a degree in web design and web development, so I was just continuing my education by taking more classes to get certified in a specific programming language.
Okay, what specific program were you going into?
Java programming.
Pardon?
Java is a programming language, so I was getting certified for that specific.
Okay. Were these classes that were going towards a master's degree?
After the software application development, yes, I did get a master's degree after.
All right. So at some point in time, after you got your degree from Mercer, did you begin teaching?
I was teaching before already. I was working for Central Georgia Technical College as an industrial aide, so essentially I was teaching.
Tell us, you were working for where?
Central Georgia Technical College. I was working as an industrial aide, so essentially my job was to run all of the technology in the classrooms that were being ran by the college for dual enrollment here in high school.
And Central, this is off Cohen Walker, is that right?
Correct.
And when did you start working for them?
I believe around June of 2019.
Okay, and this was after the baby was born, is that correct?
Correct.
Were you and Kadeem Ambrose still living together at that time?
Yes, it was.
And tell the jury, if you would, if you worked for the college there, where that job took you to.
My main location and my office was in Jones County in Milledgeville, Georgia, where I spent most of my time until COVID happened. And then due to low staffing, I had to then take over other offices in the Warner Robins area.
Oh, okay. You take other offices at other schools, is that correct?
Correct.
Which other schools would you work in?
The Housing County Career Academy here in Warner Robins.
And that's off Russell Parkway?
That is correct.
Okay. And where else?
The Central Georgia Technical College at Cohen Walker.
Okay. And were you still working at the school in Jones County?
Yes, I was doing all of them.
Okay. How often would you go to these different locations? Would you report every morning to the college and then drive to either the Jones County High School, or how would you do that?
It would depend on which classes I was monitoring that day. So I would typically get a schedule for the semester at the beginning of the semester, and it depends on whether or not the teacher was canceling class or not. They would let you know, and I would either go to the location or I would stay in my office in Jones County.
Would you do this 5 days a week?
5 days a week, yes, sir.
Okay. And in doing this, Carter, did you continue to teach? When did you leave teaching here for the college?
I signed my contract with Gwinnett County Public Schools in October of 2021. So I was scheduled to leave here and started working there in January of 2021. I'm sorry.
Make sure we get the dates
I'm
right.
sorry. I signed my contract October of 2020 with Gwinnett County, and I was supposed to start working with Gwinnett County in January of 2021.
And Carter passed away in November.
Yes, he ended up passing away in November.
Now, so I take it, well, let's, because we're doing these things in a sequence, you, after Carter passed away, did you subsequently move to Gwinnett County?
I moved to Gwinnett County when I started my job, so I would say maybe a week before the semester began, so around January 6th of 2021.
And what school did you work at?
At the time, I was scheduled at Peachtree Ridge High School.
And how long did you stay there?
I stayed for 1.5 years because I was promoted after that.
And did you stay at that school or did you go to another school?
I went to open a school. That was part of my promotion to help open the computer science department at Second High School.
Your Honor, can we approach?
Yep.
Ms. Davis, tell us again as to which high school you went to work for after Peachtree Ridge.
Second High School.
Okay, spell that.
SECKINGER.
And that was a high school, a public high school
Yes, it had just opened 3 years ago.
in Gwinnett County.
Yes.
And you stayed there until that you were arrested on this charge.
That's correct.
And that was when?
That was in October of 2023.
And since you were arrested, you were prevented from continuing to teach, is that correct? At that school?
Because I cannot physically be there, yes. So that was my only condition.
And you're currently living with your grandfather under house arrest, is that correct?
That is correct.
And that's in Little Robbins.
That is correct.
Objection, Your Honor. This isn't relevant.
The objection sustained, the jury will disregard any reference to the conditions of her pretrial release. Moving on.
All right. Now, Ms. Davis, let me ask you this. Carter, his date of birth again was when?
January 14th, 2018.
And at the time that Carter was born, did he develop any problems as far as being sickly?
Yes, he did.
Okay. Once again, you were living in San Piper Apartments with Mr. Ambrose?
I was.
Was Carter hospitalized soon after he was born?
I'm not sure how soon it was, but he was hospitalized for sure right before his first birthday.
And for what type of problems?
He was having breathing issues, and he was admitted into the NICU for a few days.
The NICU where?
In Macon.
At the time that this happened, were you and Mr. Ambrose still living with each other?
Yes, he was.
At some point in time, who was your doctor for Carter?
Dr. Waters
And where was Dr. Waters at?
at Primary Pediatrics.
And that's the primary pediatrics that we've been talking about all week, is that correct?
That's correct.
At some point in time, did you and Mr. Ambrose move from where you were living at Sandpiper Apartments?
We did.
Where did you move to?
We moved to 6080 Lakeview Road, which was the doctor's office. It was right next to the doctor's office.
Okay, how far away?
There's 6082, so I would say maybe a few yards, not even.
And was that primarily a reason for you moving to this location?
Yes, because of my child's medical conditions, I felt more comfortable moving closer to the doctor's office.
would it be a fair statement to say that you spent a lot of time at pediatrics, at the pediatric place?
A lot of time, yes, I would say, yes,
And you were aware, or not, of all the medical reports that were provided by their business, is that correct?
that is correct.
And as far as you know, this is a true and accurate representation of the times that you took Carter to that place for treatment, is that right?
That is correct.
What type of treatments?
You mean what type of things that he
Right.
go for? He's been for allergic reactions, he's mainly been for breathing issues, and his minor checkups, regular checkups, and any COVID testing or anything that we need to do.
At some point in time, did the relationship between yourself and Mr. Ambrose, did it dissolve or end?
It did.
When would that have been?
I really can't tell you when it started to dissolve, but I know for sure when he moved out in March of 2020.
Okay. He moved out in March of 2020, is that right?
Correct.
And you were still teaching at the college, is that right?
That is correct.
During this period of time, you say it was March of 2020 when Mr. Ambrose moved out.
That is correct.
Did you maintain contact with him from the time that he left until Carter passed away?
Contact as in regarding the child, yes.
Was he paying child support?
He was, we had an agreement before I actually initiated the court order child support.
All right. Now, during this particular period of time from after Mr. Ambrose left, where was Carter being? Was he getting daycare, or how were you doing about keeping him when you worked?
Yes, so I would take him to daycare before work, and then I would pick him up in the afternoon unless his father was off from work or was able to, because his schedule didn't allow him to take him to work because he didn't get off in the time frame.
All right. And where was this daycare at?
Off of Russell Parkway near one of the
Would that have been with Ms. Stark who testified
That's
this
correct.
week? And how often would Ms. Stark keep Carter?
She would keep him pretty much every day unless I had a day off or his father had a day off.
And did that involvement between yourself and Mr. Ambrose, was that fairly successful as far as looking after Carter?
Sure, yes.
Okay. No, there weren't any problems with that?
No, because we did everything around his head.
And the schedule that Mr. Ambrose worked with the fire department was, as he testified yesterday, 24 on, 48 off. Okay. And you recognize that he had a part-time job at some point. Now, let me move on to November of 2020. Up until then, was Carter a happy child?
Yes, very much.
And for the most part, was he fairly healthy?
For the most part, other than his medical issues.
And if there was a problem with Carter, you would take him over to the pediatric place, is that correct? And you fairly regular over there?
Yes, I'm a regular.
Ms. Davis, I'm not going to, and you know, Mr. Dwayne may ask, but I'm not going to get into, we've all heard what happened on the 17th of November. At that particular point in time, the day that Carter passed, where were you at physically?
The day that he passed, I was at work
Where at?
in Milledgeville, Virginia.
And that was for one of the high schools up there, is that
For
right?
Johnson County High School.
And Mr. Benton was watching Carter, is that correct?
That's correct.
Did you, when you found out that Carter was in distress, where did you go to? Where did you rush to?
I was on the phone with Mr. Benson, and he informed me that they were transporting him to the emergency room, so I met them at Pekin County Medicine.
Now, the information that you provided to the sergeant in this matter, and also to Lieutenant Meadows, and we heard the video, to your recollection, the way of thinking, is all that true and accurate to the best of your knowledge and belief?
Yes.
As far as the timetable is concerned, did you lay that out for Sergeant Collins and also for Lieutenant Meadows?
I did.
On the Monday night before Carter passed on Tuesday, did you contact his father, Mr. Ambrose, as to whether or not he could watch the child?
I did.
And why was that?
Because I felt more comfortable with him being home with either me or Mr. Ambrose. However, I could not take off work that day, the next day. So I asked Mr. Ambrose if he could possibly take off work to watch him.
And he would not, is that correct?
That is correct.
Were y'all going through a little bit of a spat as far as the child support order is concerned at that time?
I was not. I think that I don't think he agreed with my going to do it through the court system. So I don't think we weren't really on good terms because of that.
But anyway, you went to work on that Tuesday.
Correct.
Ms. Davis, let me ask you this. As far as did you ever do anything to harm your child?
No.
I mean, this jury has to decide these charges against you. Was this child ever harmed or hurt or injured by you or in your presence? Now, Mr. Benton, from time to time, had been at your place and looked after Carter, is that correct?
That is correct.
Your sworn testimony. Has Mr. Benton ever done anything in your presence or to your knowledge where he would harm this child?
No.
Did you ever take any action to where as though you felt like you were being negligent in taking care of the needs of Carter?
No.
Do you recall the child at any point in time falling or hurting himself or being in an accident of some sort there at the residence?
No, I did not.
The Saturday before, you were at your granddaddy's house, is that right?
That's correct.
Did you keep a close eye on Carter the whole time?
Yes, this is always up under me.
Ms. Davis, this happened almost 6 years ago, and do you still remember what happened during those days before?
Vaguely.
As you have explained once again, what happened then to Sergeant Collins and Lieutenant Meadows, do you stand by what you said?
Absolutely.
And also Marcus Jackson from DFAX was there, is that correct?
That's correct.
During the period of time after Carter passed away, did you try to stay in touch with the sheriff's department or law enforcement of some sort as to what was going on with the investigation?
Oh, yes. Yes, absolutely.
I mean, what would you do?
I was consistently calling them for the 3 years.
And who would you talk to, do you know?
They would never come to the phone. I was always referred to an assistant who would leave my number, and that they would get back to me, and they would never get back to me, which is why I continued to call.
Would that just be law enforcement, or did you also try to contact the district attorney's office?
But I would contact Warren Police Department, the Sheriff's Department, and the District Attorney's Office.
And you heard the testimony of Sergeant Collins, and you met with him, did you not? And right after Carter passed away, and then a few weeks later, is that
That's
right?
correct.
Did you ever talk to him anymore?
We did have one phone conversation, and that's all.
And when was the next time you heard from anybody from the sheriff's department?
I did not hear from anyone from the Sheriff's Department anymore after my last meeting, or Sergeant Collins.
Okay. At some point, have you heard from Lieutenant Meadows, is that right?
A year later, yes,
And you drove down to meet with him, is that right?
that is correct.
And, are you standing by the conversation or the information that you provided him at that meeting on December of 2021?
Correct.
Did you still continue to try to get in touch with law enforcement about this?
Yes, for 2 more years.
Did they ever call for you to come down here and meet with them anymore?
No, they did not.
The whole time you were teaching in Gwinnett County, is that right?
That is correct.
In addition to law enforcement, did you also talk to the coroner's office?
I never spoke with the coroner's office.
Ms. Davis, you're under oath. Once again, did you ever do anything to harm a child?
No,
Did you ever do anything to where you were reluctant or unwilling or unable to seek medical care for this child?
no.
That's all I have. Thank you, Ms. Davis. Mr. Jordan, you have some questions?
Good with you, Counsel.
State's Exhibit 11. What is that?
That is a picture of my child's liver.
Your child's liver. That's quite a laceration, isn't it?
It is.
It is. And you heard the testimony that it would be 24 to 72 hours out. So either Monday morning to Saturday morning, correct?
Correct.
And he was just telling you his stomach hurt?
He was pointing at one point saying my stomach hurts, and that's all.
And you heard Dr. Eisenstadt say this is a serious injury, right?
I did.
And that quite a bit of force would be needed in order to cause that injury.
That is correct.
But so Monday, he was just okay?
Monday, he was throwing up. I was at work all day Monday, so I did not see him all day. I only saw him during the period of time when I returned home for lunch and when I returned home after 5 p.m.
Okay. And he was hurting overnight though, wasn't he?
No,
He wasn't?
overnight with it.
Sunday.
Sunday, no, he was not.
Now, you said just a minute ago that you stand by the statements that you gave Collins, correct?
Correct.
And in your first statement, you told him that the symptoms started Sunday night.
I told him that on Sunday. He told me that, Mommy, my stomach hurts, and that was all. On
No.
Sunday night.
That was not your first statement to him.
It was my first statement to him.
Well, we all watched it.
We did.
And they can watch it again.
They can.
Yes, they can. So Monday, he's throwing up. Is that right?
Monday, when I got home from lunch, I suspected that what was on the floor was a puddle of juice. I did not suspect at that time that it was thrown up until after he threw up with me after I returned home around 5 p.m.
But you didn't take his calls for help seriously, did you?
I did take it as seriously as I could from what I was presented and what he was showing.
I think you had said that he'd never thrown up like that before.
He has thrown up.
He has thrown up like that before. But he's a crybaby, isn't he?
He's a crybaby in the sense of he would tell me or he would cry if something was seriously injured or seriously wrong.
He would tell you if something seriously wrong with him?
He would be crying and he would notify me that something was wrong with him.
Is it?
Pointing or making, like I testified for, like I said, he wasn't at a point where he could say full sentences yet, so it would be fragments of this, mommy this, mommy that.
Well, is it a 2-inch laceration to a 2-year-old's liver serious?
Yes,
It's very serious. That's why he died, right?
correct.
But he didn't say, point, he wasn't crying, it wasn't really alarming to you, was it?
He was not crying, he was not crouching over, he was not holding his stomach, he was not doing anything except for saying, Mommy, stomach hurt, and vomiting juice.
And you expect the jury to believe that a 2-year-old crybaby, who you said cried over everything, who had a 2-inch laceration of his liver, wasn't really crying?
I expect him to believe what I saw and what I presented.
When did you break up with Kianna?
Me and Kianna ended our relationship around February of 2021
Why?
because
Because why?
we did. We just broke up. That was my first time dating. And 2, all of this was going on, so it was really a lot for me to even try to be in a relationship with anyone or focus on anything other than my child in this case.
And you knew him, right?
Correct.
And you repeatedly denied that he would have done anything to your child.
That is correct.
But you denied that you did anything to your child.
Absolutely.
And the time frame, as we've all heard, is that you and Kianna were the only people who had access to him.
During Sunday to Monday.
Right.
Correct.
Right. Other than the Saturday that you were at your father's house, right?
Right.
Okay, but he was fine that day.
He was running around.
And then Sunday is when he's not feeling well?
Sunday night is when he first mentioned Mommy, my stomach hurts.
Okay. And then it's Monday?
Monday, after I got home from work, yes, we had to do it again.
But you say Kianna would never do anything like that.
That is correct.
But you deny having done anything.
That is correct.
So who would have done it if the only 2 people were he and you?
That is a good question.
So we just don't know.
We don't. Considering, and I will say this, nurses, they've all testified that my child did not have bruises on his body when he was presented to them. That is Tuesday morning. So, according to that time frame that you're trying to give me, by Tuesday morning, if something like this would have happened, he would have absolutely shown bruises or something on his body to a complete staff of medical professionals. And every one of them got on the stand and testified that they saw nothing. So, I also did not see anything to a point where I thought that I needed to rush my child to an emergency room after hours, after everyone's already off. I did not get home from work until 5 o'clock. That is after hours. I would have had to make an after hours appointment. I did not choose to do so because that was the first time that my child had grown up in my presence. And I believe that keeping him home would have sufficed for enough time for us to be able to monitor him and then decide from there what we needed to do.
So you said you didn't see anything.
I did not see anything.
Right. At some point you said you gave him a bath and you complained his balls hurt.
I was washing his balls, scrubbing his balls, obviously, because he had glue on himself, and he said, ouch. And I assumed was rubbing his balls too hard.
Well, and I'm looking at State's Exhibit 10, which is a picture of that very region of his body.
Correct.
Okay, so he said, and is that not kind of a weird place to have a pain?
Not while I'm rubbing it, no.
Okay, so you never saw the injury,
I never saw
Yeah.
it.
you had no idea.
I never saw it.
What about the injury to his cheek?
I was not aware of anything with his cheek.
No, you didn't tell Sergeant Collins that was from a hickey?
I did not tell him it was from a hickey. I told him that me and my child often kiss each other and like to suck on each other's faces.
And is that what caused that mark?
I have no idea.
So it could be from you sucking on your child's face.
Could be I have video of me sucking on his face.
Now, it's your testimony that you and Kadeem moved to that Lakeview Road apartment so you could have easy access to the pediatrics office, right? And we've seen the medical records, correct?
That is correct.
And he said that you were irregular.
That is correct.
And what would you take him in for?
There have been multiple allergic reactions randomly. He also had breathing issues that either they would send us to the emergency room for, or they would already be there, or it was regular checkups. And then, of course, I always saw them whenever his allergies would flare up or his vomiting or milk.
And you didn't have any problem taking him right away, right?
I didn't take him right away then either
Okay. You never took him right away?
to the doctor.
Yeah, I mean, if you had a problem, you just took him to the doctor, right?
No, you have to make an appointment.
Okay. You have to make an appointment?
That's correct.
Okay, well, obviously you have to make an appointment.
That's obvious.
Would you make an appointment once you saw the symptoms?
I would make an appointment once I monitor his symptoms.
Once you monitor his symptoms?
Yes.
Like you monitor his throwing up?
From 5 p.m. until the morning that he passed.
Were you monitoring the symptoms when he threw up in his sleep?
I was sleeping, so no, until I went into the room. That was my intent to get up in the morning. I set my alarm to get up in the middle of the night to go and check on him.
But you were aware that he threw up while he was
Yes,
asleep?
correct.
And that wasn't alarming?
It was at that point, that was my very first alarm because he had to do it in his sleep and not while he was awake.
Mm-hmm. But you don't call Monday when you get up, right? When you wake up Monday, you just go to work.
Why would I need to call anyone on Monday?
I don't know. Would you potentially, you just said it was alarming that he threw up in his sleep.
That was Monday night.
Okay. And then he threw up again Monday, correct? So Monday he throws up in his sleep, which you say is alarming, but you go to work.
Monday at 3, that will be Tuesday now at 3
Okay, it's
a.m.
Tuesday? See, I'm still hung up on the fact that you told Collins that these symptoms started Sunday.
I
When you first
told
got
Collins that he first mentioned that his stomach was hurting on Sunday. On Monday is when I went to work. He was at home, and when I came home from lunch, he was sleeping, and there was juice on my floor. And what I presented was juice because the sippy cup was sitting right beside it, tipped over.
Right, but I guess my point is that on the first interview that you gave Collins, you told him that the kid was throwing up, Carter was throwing up Sunday. It wasn't until a month later, a couple weeks later, that you told him, oh, now it's Monday.
I did not, and also I spoke with Mr. Collins the first time the day after my child had died. So I was completely discombobulated that day.
Okay. And so you had kind of no idea what was going on. You're just monitoring conditions, but Carter's just happy as can be.
I'm monitoring his conditions, yes.
Right, and Carter's fine?
From my understanding, he has not yet thrown up in my prison.
Okay, so why doesn't Kadeem get to FaceTime his child?
Me and Kadeem were going through obviously a court battle, and he was annoying me, so I blocked his number. He could still contact me via either email or he could call my child's tablet.
He was annoying you by trying to figure out his overpayment of child support.
Why would he be overpaying for child support? That doesn't even make any sense.
You heard his testimony.
Why would he give you money for child support if he knew that he was overpaying?
I mean, he provided
He
his
gave me the money,
response.
that is correct. So that would not be overpaying, that is a voluntary. I'm giving you the money.
Stop emailing me. No, you can't get her talk to Carter. Leave me the fuck alone. And that's the last time I'm going to tell you.
Correct.
All right. So, but you heard Kadeem's testimony about how you would block him when you got mad, but that he would always get to see his child, FaceTime or talk to him.
You also heard him say that he can only get his child during the time in which he's off work, so that would mean that he would have to be off work from his part-time job and his job at the fire station, which is not something that he can just say, I'm off. It's based on his schedule.
I'm not talking about his work schedule and whether or not he gets to keep Kadeem. I'm talking about the fact that his testimony was that even when you would block him, when you'd be mad at him, he would still see his child on FaceTime or be able to call the child. And now, the weekend where your child's suffering a lacerated liver, all of a sudden he can't see his child.
No, I called him on Monday and asked him if he could watch the child.
Right. You called him Monday at what time?
When I got off of work, when he threw up in my arms.
Okay, after he's been sick for a while?
I just saw him throw up for the first time that moment.
You saw him throw up for the first time at that moment when he was in your arms?
Correct, he threw up with me.
Okay. And that was when or where?
Monday in the kitchen.
Monday in the kitchen.
After I got from work.
Okay, so we had the red flag in the middle of the night. Was that?
That was after.
That was after? Okay. All right, so you called Kadeem and said, come here.
I called Kadeem and asked him if he would take off of work to watch him that whole day and monitor him. Yes.
And then after the fact, you blamed him for this, right?
No,
Yeah? You didn't say if he had just come get him, none of this would happen?
I do not recall saying that.
You don't recall saying that, but you heard Kadeem say that.
That may be his feelings. I have nothing to do with that.
What do you mean it has nothing to do with that? It's a conversation between you and him.
No, it's a conversation between you and him, or him and his own thoughts that have nothing to do with me.
So Kadeem's just making stuff up.
What would he be making up? He said out of his mouth, if he would have gotten the child, it probably wouldn't have happened. I had no control over that. All I could do was pick up the phone and ask my child's father, can you watch your child? And considering that she had just been calling me for 2 days, asking me if you could see the child, I would suspect that she would assuredly want to watch the child, especially knowing that he was sick. But he told me no.
Or, none of this would have happened meant that the finger would have been pointed at him.
No, I don't know what you're referring to.
Right?
Why would I tell him that? He's my child's father. He's never.
Why would you tell him what?
Why would I tell him that if none of this would ever happen if he had been watching my child?
Well, if the child died on his watch, we point the finger at him.
We didn't know the child was injured at the time.
You didn't know?
No,
No. Just all this throw up, my tummy hurts.
correct.
Mhm. And you stand by your statements that Keon would never do this.
I stand by my statement that no one around me would ever harm my child.
So, if Monday he's throwing up, why didn't you just make an appointment for him then?
I asked for my child's father, who is an EMT and a firefighter, to watch his sick child. He is fully medically trained to watch his own child. He is medically trained to take care of anyone who is in an emergency situation. So yes, I went to him first before I took him to the doctor.
Well, you didn't take him to the doctor.
Correct, I did not have time. He passed away at 8:40 or 9:30 that next morning.
Right, well, but he was sick in the morning, wasn't he?
I went to work that morning.
Right, and that's my
I
point.
FaceTimed him, and I told Keon to rush him to the doctor's office, which was next door.
So after you couldn't pawn him off to Keon, or to Kadeem, you wanted to leave him with Keon.
Don't pawn him off to his own father? How is that?
This injured child, yes. Yes,
At
so
the
you just
time,
go to work.
he was injured. At the time, the only thing that he was presenting to us was throw up.
Throw up in his stomach hurt really bad.
Not really bad. Mommy, my stomach hurt.
Not really bad, a 2-inch lacerated liver, but he's telling you his stomach just hurts. It's not really bad. He's not crying, nothing.
He is not crying. I work with children. I would have suspected someone of this magnitude to be crouching over, to be holding his stomach, to be indicating something of pain.
I think we all would. So when Kadeem doesn't take Carter, you don't make a doctor's appointment for him.
It's at this point around 7 o'clock, and after hours is what you would have to do in order to get an appointment. You would have to call the number, and if you get an appointment, they will then tell you that you can come in at a certain time the next day. So there's no instance where he would have been able to see any medical professional unless I called 911 that day.
Urgent care's open?
I don't know about urgent care.
Emergency room's open?
He did not present any symptoms where I felt like I needed to take him to.
And that's not what I asked you. I asked you was an emergency room open?
I'm assuming
You're assuming
emergency rooms are open.
they're not open 24 hours?
I'm assuming they're open 24 hours.
You assume that's not something that you just know, you're just guessing that that's true?
I don't work for an emergency room, so I don't know.
And neither do I, but I don't need to work for an emergency room to know that I can go there at any time.
Correct.
Right, so you do know that.
You can go to an emergency room at any time. That's basic information.
And if you had called your doctor, chances are you would have gotten a recording that said this is after hours. If this is an emergency, please hang up and dial 911.
Correct.
You did none of that.
Why would I need to call 911 for vomit or juice?
Or go to the emergency room.
He was vomiting juice, and this was not the first time that my child had vomited. And the first time that he was vomiting, we did go and see a doctor, and she told me that because it could be allergic reaction, that he would eventually get over it. So no,
But it is the first time that he vomited in his sleep and didn't wake up.
he did wake up.
He did wake up.
You just heard them say that he was on the phone with me, and he was awake.
In his sleep the night before.
In his sleep, the night before, he threw up in his sleep. I took him and I moved him to the other bed. When I got up that morning for work, which was a couple hours later, he was wide awake and he was talking.
And you were on the phone with Keon when he was taking your dying child to primary pediatrics, correct?
I was on FaceTime the entire time.
Okay. Do you remember any of the statements that y'all made on the phone?
Statements on the
Do you remember any part of that conversation?
No, because I was at that point driving from Milledgeville. I ran out of my office and I was driving from Milledgeville back to Monroe.
So you don't recall if Keon said to you, man, I should have brought him in last night when you told me to?
No,
Why would you have told him to take Carter?
that's a very good question because why would I tell him to take him?
Right, well, I mean, you did tell him to take him
I
Tuesday
did not
morning.
tell him to take on Tuesday morning.
You did.
Why wouldn't I tell him? He's the only one with him.
And he said, don't worry about that right now, just get here. Do you recall that?
I do not.
In the daycare, Miss Shirley, right? How long have you been knowing her?
I've known her since my child went to daycare.
And you kind of went to high school. You went to high school with Gazette
I did, but we did not hang out, no.
until you started bringing Carter to her mom, and then you guys kind of had more of a friendly relationship.
No, I never had any type of relationship with Gazette until after my child passed.
Okay. Till after your child passed. So what was that relationship like?
There was no relationship. It was more so they had a party and she invited me over and I went to her place and that was the last time that I saw her spoke to Gazette.
And you took wine to her place, right?
I did not take mine.
So you didn't go to her place to pick up a plate?
I went to her place, like I said, they were having a party of some sort and I went to pick up a plate of food. Yes.
You don't even know what kind of party it was?
No, I don't.
You don't recall it being a Christmas party?
No,
You don't recall that Kadeem took Christmas gifts there?
he didn't tell me that he took Christmas gifts. So
Okay. But who called you and told you that you could get a plate?
Gazette,
Gazette did?
Yes.
And you could pick it up from her house?
correct.
And you guys didn't discuss anything while you were there?
No,
You didn't tell her that he had a lacerated liver?
I don't recall, no.
Okay. You don't recall? Well, you just said that you didn't talk to her at all, and now you're saying you just don't recall it when you said.
I just said I don't recall telling her that my child's liver was lacerated. I obviously had conversation with her because I was at her place.
And you told her that you Googled it?
I don't recall telling her that.
You don't recall telling her that it could be because he jumped off the couch?
No, I don't recall telling her anything, but if I did, then I would probably have said what I researched.
And you never blamed Keon?
No,
Well, Miss Shirley, did you keep in contact with Miss Shirley after Carter's death?
not really, other than her checking on me, no.
So you guys had a discussion though, right? She would check on you. Would she just say, are you okay, and hang up the phone? Or would you guys actually exchange words?
I don't recall.
You don't recall
It was
anything?
6 years ago. I don't recall.
It was 6 years ago. Well, she just testified that that's what happened.
That is what she testified to. That's not my recollection of the conversation.
She spent a lot of time with your child, didn't she?
She watched my child.
Pretty much all day unless Kadeem wasn't at work, right?
Correct.
Right. She loved your child, didn't she?
Sure.
And she made, what was it, a pillow with his picture on it?
She did.
And at his viewing, he had some kind of vehicle in his hands, didn't he?
He did.
And that was her vehicle, Ms. Shirley's, right?
I'm not sure.
You're not sure, and you didn't give it back to her?
Why would I shoot left it in his casket? I'm assuming.
But you guys would never discuss anything after this? About Carter?
No, I did not.
Okay, so you never told her that he fell off and hit his head on the bed?
No.
So everybody's lying,
Yeah.
except you.
Why would I have to lie?
Well, why would the forensic pediatrics people lie?
What did they lie
About the statements that were made on the phone
What do you
with you and Kianna. The people that you love, that we saw on the body cam, how broken up you were for them. About what happened to this boy because he was a regular and they knew him so well. The moment you went into the office, they knew you. Right? So why would they make up these statements that are made on the phone?
They only said that I told him to, or that he said, don't worry about it, just get here.
Yeah, and what were you doing?
Driving.
You were driving?
Correct.
Okay. And where were you coming from?
Milledgeville, Georgia.
What age kids did you work with? I think it sounds like maybe they were college students.
They were high school students.
High school students? But you don't really know anything about the statements on the phone.
I was driving. They just told me my child was being rushed to the emergency room. I'm driving. I have an hour drive. I'm also trying to contact his father to notify him of what's going on. There's a lot going on, but I'm trying to drive on the highway.
So what is Kianna referring to when he says don't worry about that, just get here?
I have no idea. I'm sure I was trying to find out information about my child.
Did you talk about this afterwards with Kadeen?
Talk
Talk about anything?
I had multiple conversations with his father.
And was there any conversation about the lacerated liver and him and Keon? And have you ever found out about something?
Every time that I would try to contact my child's father about the case or anything involved in the case, he did not want to talk about it, which I can understand that he didn't want to have more conversation about it at this time.
Well, I don't think that's what I'm referring to. Because didn't he testify that he told you that he didn't know what he would do if he found out it was Keon? Didn't he testify to that?
That's what he said. I didn't know. That's his personal, emotional.
So he's lying too, or what?
Lying about what? That's his personal, emotional feelings. He doesn't know what he would do if he found out someone else did something to his child. That has nothing to do with him.
Yeah, I'm referring specifically to the statement of that he made to you. He said that, right?
He did say that.
And what was your response?
I don't know.
Well, according to his testimony, you defended him, right? You defended Keon.
All I said was
You got mad at me.
I did not get mad at Keon. All I said was I do not believe that Keon would ever harm my child.
And so we know that Carter had his own bedroom in your apartment, correct?
Correct.
Okay. And that there was kind of this battle between keeping him in his own bedroom.
Not a battle. He was sleep trained.
He was sleep trained.
Yes, so I was training him to sleep in his own bed.
But he would come and knock on your door or try to find you.
Obviously, he would get up in the middle of the night and try to come back and sleep in my bed, yes.
Okay. He would. What about if you and Keon were in the bedroom with the door closed?
We wouldn't be in the bedroom with the door closed.
Well, what about, where would you guys smoke marijuana?
He did not smoke marijuana in my house. He would smoke outside or on the patio.
And the smoke outside on the patio?
On the patio.
So you never had anything to do with any of that?
I never had anything to do with any of that.
Try to get a new phone after this?
Did I try to get a new phone?
Mm-hmm.
As in a phone number or?
A new phone, like upgrade your phone?
I believe I did upgrade my phone only because me and his father shared a phone at the time of our line, and I was returning his, and I was eligible for an upgrade, so I believe that I did upgrade or whatever.
When did you become eligible for an upgrade?
I don't know.
Does December 6, 2020 sound right?
I don't know.
Okay. Do you know how many times you checked to see if you actually qualified for an upgrade?
I would never check to see if I qualify for an upgrade. I don't know. Sure.
Do you have any idea what that is?
Those are records of an eligibility check from, I guess, my account.
From your account? And there were a lot of pages, weren't there?
They are
Okay, what were the dates?
from November until, I believe it was January, I don't know,
Until December?
December, January, and the last day.
That's quite a few pages, isn't it?
Eligibility request for upgrade on my cell phone.
Mm-hmm.
Sure.
Okay. A lot of them came right after this incident happened, didn't it?
Sure. But I mean, I work in tech, so we upgraded my phone, had no bearing on anything, because everything was then transferred over to my new phone.
Why did you tell Kianna to get him the breathing treatment that morning?
Because Kianna had mentioned that he didn't think that he was breathing correctly. So I immediately said, well, I asked him to lift up his shirt so that I could see if he was retracting a little bit. I did not notice him retracting, but because he stated that he thought that he was breathing properly, I told him to get him breathing treatment anyway.
And you knew the signs and symptoms, right?
Yes, which is why I asked him to lift up his shirt.
Right, and you didn't see anything?
No,
You said get the breathing treatment anyway.
correct.
You don't recall saying that Carter threw up 4 times Sunday night to Collins in your first interview?
I don't recall anything from that first interview. Again, I had just lost my child. It was a lot going on.
How many times did he tell you his stomach hurt?
I don't know.
Was it once?
He told me Sunday nights. I went to work on Monday. I never heard him say it again until I returned home and he threw up in my face. And then he said, Mommy, my stomach hurts.
Did you give him a bath after that happened, or did you give him the bath prior to being in the kitchen?
I gave him a bath when I got home because I noticed that he had juice all on his shirt.
But it wasn't juice, was it?
It was juice.
It was juice?
It was juice.
What was on the carpet?
Juice.
Juice was on the carpet?
Juice.
Okay. But you said that you kind of deduced that it was throw up at some point in your statements to law enforcement, right?
Throw up, in my mind, is throw up, which it should contain food, some sort of consistency, chunkiness, something. This was not that. This looked like water mixed with juice.
So, then why did you tell law enforcement and you kind of figured out later, once he threw up in the kitchen, that you figured out it was throw up?
I said, because when he threw up in the kitchen, he also vomited the juice and clear fluid. So I then immediately said that must have been what I noticed on the floor when I came home from work.
You said there was something I would tell you to law enforcement once they told you about the injuries, right?
Of course.
So there's nothing.
I did not witness any type of anything, no. And there was no evidence of any bruising or anything on his body to me, nor was there any evidence of any bruising on his body to the medical staff who saw him that Tuesday morning.
But Carter didn't run to you and point at Keon and say he hit me.
No.
And he reviewed that, right?
He never said anyone hit him, but if anyone did hit him, he would point to whoever. I would ask who did it, as I would refer to my child, and he would point and tell me who he thought would do anything.
Right, like if he got hit at daycare or something like that.
If he got hit at daycare, I wouldn't have known unless he started told me.
But you said if anything would happen, Carter, who was a crybaby in your words, would come to you and point at what happened.
Carter's always the last one to be picked up from daycare because I am the latest parent to pick him up. So whenever I pick him up from daycare, he is typically the only child there. So there will be no one to point to.
Okay, then why did you tell police that?
What
Why did you tell police that if someone hit Carter, that he would tell you,
Because he would.
but he didn't do that with Kianna?
So that obviously means no one hit him.
Nothing further, Judge.
Thank you.
I have nothing else, Your Honor.
Step down, ma'am.
Ms. Davis, come back, please.
Do you have any other evidence to present, Mr. Brewer?
No, ma'am.
All right, the defense rests. Does the state have rebuttal?
No, Your Honor.
All right, ladies and gentlemen, we have some stuff we have to do outside your presence, and it's time for lunch. So I'm gonna give you a little longer lunch break today so that we can take care of what we need to do, get some lunch, and then we will resume at 1:45, and we'll hear the closing arguments from both sides, and then I'll give you the law that applies to this case, and then we will begin deliberation. The evidence is closed. It is still, however, improper for you to discuss this case with each other or anyone else. It will always be improper for you to do any independent research. So leave your notepads in the jury room, grab some lunch. I'll see you back at 1:45. You may be excused with those available. All right, let's get on being back at 1:15-ish to do a charge conference. I think you guys both have the version, which I've already taken some stuff out, because you didn't call some witnesses, I thought you might, and so forth. But that'll give us a starting place, and we'll do a charge conference at 1:15. Mr. Dwayne, are you going to open and close?
Probably.
Okay, so we'll do that, and then we'll do the closing arguments and charge. Okay? 1:15 for you guys, 1:45 for the jury. We'll stand and recess. State of Georgia versus Kianna Davis. Are you all right?
Yeah.
All right, we are back on the record in the matter of State of Georgia versus Kianna Davis. We are outside the presence of the jury. We're going to have a charge conference, and the defendant is present with her counsel and the state's counsel. So I'll let Mr. Grooves request a charge sitting in the middle of my desk. They're on the front part of the desk, right where you're sitting.
I have another copy for you.
It's okay, I got 2 copies on my desk, Mr. Grooves. You should be able to hand them to me and just keep up with them. I just sat them down earlier and then. All right, let me tell you what I've got, and then we'll go through each of y'all's requests. And when I refer to what's in the draft I have already created, it is the most recent pattern charge unless I say otherwise. So I have issue and plea of not guilty, presumption of innocence, burden of proof, reasonable doubt, grave suspicion, jury as the judges of law and facts, evidence generally. I have used the short version of direct and circumstantial evidence, credibility of witnesses, expert witness, witness impeached, prior statements, thank you. Immunity, okay, we don't need that one because the co-defendant did not testify.
We agree, Your Honor.
Take that out. I have single witness corroboration, defendant's choice not to testify can come out.
And also, you had accomplished corroboration, that comes out.
Yeah, and okay, so I have, before we get to that one, I have the statement of the defendant. And I did not put all of the Miranda stuff in there, but I did leave, initially, hold on a second, I'm trying to, yes. I think I left the draft over on my desk. Okay. So the pattern statement of the defendant says, the statement of the defendant allegedly, and it says, made while in custody has been offered for your consideration. So determine whether the defendant's statement was voluntary, and if the statement was in custody, whether the defendant was properly advised of her constitutional rights. Well, that's, I mean, either, you know what I'm saying? I don't know why it's phrased that way. Because my intention had been at first to give statement of the defendant 1.32.16 and voluntariness 1.32.17 and not the rest of that about Miranda and all that, because we all agree these are not custodial interrogations, or whether or not we all agree to that. That is what the evidence is and what the court has found. So I guess my first question is, do I give it at all? Is it appropriate to give those 2 paragraphs? And if so, then I'm going to read a statement that the defendant allegedly made has been offered for your consideration and take out the while in custody, and then just leave those 2 paragraphs, otherwise it's written.
That's fine, Your Honor.
Because voluntariness is always an issue, even when Miranda in custody is not.
The new version appears to have the while in custody in parentheses.
Okay, maybe that's just it. When I cut and pasted, I didn't. Okay, so see, the pattern is going to do what I said we should do anyway. So yay me. Okay, so we will leave that a statement that the defendant allegedly made has been offered for your consideration before you consider blah blah blah. Okay, that one's good. Let me take out mine. I had highlighted some stuff that I know we would need to discuss. So that comes out, and then voluntariness. Then I have, and I think in the version I printed for you, all the accomplice stuff was in there. I took that all out. Okay, so then I have definition of crime, intent, no presumption of criminal intent, parties to a crime, principal, failure to prosecute, knowledge, mere presence, mere association. I added, and I can't remember if I did this after I gave you a printed copy or not, I added statute of limitations. So it reads, and I had to do a little, the statute obviously is different for murder than it is for the underlying felonies. So it reads like this. Members of the jury, the law of our state sets a time limit upon the state in starting the prosecution of most criminal offenses. The accused is on trial for the offenses of murder, aggravated assault, cruelty to children in the first degree, and cruelty to children in the second degree. Under Georgia law, there is no statute of limitations for murder. However, prosecution for the offenses of ag assault, cruelty to children in the first, and cruelty to children in the second must begin within 4 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit this defendant.
That's fine.
All right, then I have venue generally. I also added some language to the venue charge because the testimony is that the official declaration of death occurred in Page County. So there is some, and this comes out of the pattern. So it says the law provides criminal action shall be tried in the county in which crime was committed. Venue that the crime was committed in Houston County is a jurisdictional fact, must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. Because I suspect otherwise we may get a question on that, and rather than, I need to be clear about that. Okay. Malice murder is the pattern. I have the paragraph on the state does not have to prove premeditation. Malice is how long or how briefly the malicious intent, no specific time, so on and so forth. Motive, you don't have to prove motive. Then felony murder, and here's the way I did this. It says, for felony murder, the state must prove the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Then I said, count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. Cruelty to children in the first degree is a felony, which I will define for you now. Then, for cruelty to children in the first degree, the state must prove the defendant maliciously caused, and let me adjust to the indictment, it's cruel physical, isn't that the way it's alleged?
Yes.
Okay, so caused cruel physical pain to a child under the age of 18 years. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse, willfully doing an act while aware of strong likelihood that pain may result. That's all pattern. Then I went on to say, count 4 charges felony murder with aggravated assault as the underlying felony. Aggravated assault is a felony which I will define for you now. For aggravated assault, state must prove that the defendant, and in this adjusted for the evidence, assaulted another person with an offensive weapon. Then an offensive weapon is any object that is likely to or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object is an offensive weapon, you may consider all of the following factors. And again, this is pattern. Nature and extent of injury inflicted, character or capabilities of the weapon, manner in which it was used, any display of it to the jury in any other circumstances in this case. Then murder in the second degree. Statements prove that the defendant caused the death of another person by committing cruelty to children in the second degree. State does not have to show malice. Define cruelty in the second degree for you shortly. Cruelty. I'm not going to do it shortly, I'm going to do it right now. Hold on. I will define cruelty in the second degree. For cruelty to children in the second degree, the state must prove the defendant caused, is it cruel pain again or excessive? Cruel physical pain. Caused cruel physical pain to a child under the age of 18 for criminal negligence.
I think you also have to define criminal negligence.
All right, and then I have verdict, which is a pattern. Court has no interest, sympathy, sentencing is the court's responsibility, deliberations, unanimous verdict, retired to the jury room, alternates go over there. Okay, let me go back and look at the malice too.
Criminal negligence is 14140.
Interesting, it's not.
Right after cruelty in the second degree.
Right. That's going to be the most common way that would be charged, but I'll make a note for the Patter Jury Committee. I'm sure they'll be thrilled. All right. I agree that that needs to be charged. Criminal negligence is an act or failure to act. In this case, it's charged as a failure to act, I think. Okay, so criminal negligence is a failure to act, which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably expect to be injured by the failure to act. Okay. Does the state have other charges that I have failed to include that you believe are necessary or appropriate?
No, Your Honor.
All right, let me go through. Mr. Groove has properly submitted his request to charge. I think we've got most, if not all of them, but I'm going to go through them. I'm going to give when I say I'm going to give it, I'm giving the most recent pattern. I'm not matching word to word Mr. Groove's, but I presume they are the same. So I'm going to give one. I'm going to give two. I'm going to give three. I do not think. All right, you want four, Mr. Groove?
Yes, ma'am.
Where is that? See. I know that's a pattern. Did we Can somebody tell me where it came from, which section it in, if I can't find it? Did we get rid of it somewhere?
Judge, I don't think so, and I've been asking it since the beginning of time.
Right, I know, and it comes straight from a pattern. I honestly I'd like to cut and paste, and I can't find it. So I want to make sure we didn't eliminate it for a legal reason.
I think years ago it came from that case, Sandstrom versus Montana.
Right.
I think it's 141.12, Judge. Presumptions and inferences.
Well, I called myself. Yeah, see, you guys are working on an old book.
We are?
Hold on. Oh, there it is. You're wrong. Y'all are correct. There it is. Okay. Okay, I'm going to put it after, no, where it comes in the pattern, right after no presumption of criminal intent.
What's wrong?
Give me just a second, y'all, because I'm cutting and pasting as we go, so I'll have it all in front of me when we get ready to start back. Okay, so we'll give 4. I'm going to give 5, which is grave suspicion. 6 is evidence. 7, the testimony of a single witness. All right, some of 7 is the accomplice. And we don't have any of that.
No problem with that coming out.
Okay, so I am going to give the first part, which is the testimony of the single witness. So I'll give the single witness portion of 7, but not the accomplice portion. So that's the 2 sections. I am going to give 8. I'm giving 9, or the current version of that. 10, an expert witness. I'm giving mere association, that's 11. I'm giving credibility of witnesses. And that, what Mr. Group has as 12 is credibility of witnesses, impeachment, and credibility. And so I'm giving all of those. 13 is not, I'm not going to give 13 because there's no witness to which that applies. I'm not giving 14 because Ms. Davis chose to testify. I am giving venue with that extra homicide section that I said, which is 15. All right, accident. Mr. Dwayne, what is your position on accident?
Well, I think the testimony of both medical examiners is that this wasn't an accident. I don't think there's any evidence that anybody said observed that he fall. I do think, despite her denials when she testified, there are witnesses who stated the defendant told me she fell. So, I guess in that context, it might be applicable.
All right, well,
a jury could disregard or not believe the evidence of the medical exam.
Right.
And there has been very little, it's not like there was a specific accident to which this injury is being attributed, but there have been discussions about that. So I'm going to give it, I think that's cleaner.
Thank you, Your Honor.
I gotta figure out where it goes. I think it goes after criminal negligence and before verdict.
Yes, ma'am. What's the, do you have the number for it?
It's 3.50.10. And this is what the current pattern says, which is a little different. An accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no scheme, intent, or criminal negligence by the defendant. And then it defines criminal negligence, and then if the defendant raises a defense of accident, state has the burden to disprove it beyond a reasonable doubt. All right, and then 17 is knowledge that goes with parties of the crime. That's in there. 18 is murder, which is in there. 19 is murder for the second, which is in there, and 20, and we've talked about the pattern there. So I think that's everything. Mr. Groove, anything else based on the way the evidence has fallen out that you would like the court to consider or charge on?
Okay.
Mr. Dwayne?
No, Your Honor.
Okay. Do you guys want a new copy of what I'm actually saying, or are you good?
Please.
All right. Now, I will tell you, I can't swear there's not a typo in here somewhere, because I'm cutting and pasting as we go, but do we put paper in there? Okay, let's see if that works. Mr. Davis, did we sit in there today?
Ma'am?
Did we sit in there?
No. I can go check. She was on.
Just, ask Danny, he filed this one. Hello. Thank you. Okay, exhibits. Everything's going out but the videos. Yes?
Yes, ma'am.
Okay.
Yes, yes.
And then if they want to watch something again, they can ask for that here. Okay, anything else before we bring the jury in for closing arguments?
No.
All right, I just said Bob to do something else, so something you blame in the jury, please. Oh. We needed an indictment. I guess we can send this one out, they know he's charged. Hold on 1 second.
In a verdict form, do we have a verdict form?
Yeah, I'll print the verdict form, I didn't, but I'll print it.
I'll make a call with you later.
Okay, does anybody care that both names are on it, or is there any?
No,
All right.
it's not been signed or anything, I don't guess.
No, it's
We're
just
not
not
wrong.
guilty by both of them.
Yeah, I mean, I'll try, and,
Actually, this one does not even have Mr., this copy does not have Mr. Benton's not guilty. Because his not guilty is in his file. But I will probably take that page out and put his not, so they both have entered their not guilties on that document. Okay. Now we can bring it in.
all right, okay.
Check out all my W's here. All right, ladies and gentlemen, at this time, as I mentioned before lunch, the evidence is closed. You're going to hear the closing arguments from the lawyers because the state has a burden of proof. They'll open, the defense attorney will then make their remarks, and the state will have the opportunity to address you a second time. And then I will give you the law that applies to this case, okay? Mr. Dwayne, there with you.
Thank you, Judge. This case is about a mother who refers to her child not by his name, but calls him the child. That child's name is Carter Ambrose, and his mother killed him. Repeatedly called him the child. He didn't have a name, he didn't have an identity, which he testified. He's just the child, like an unnecessary piece of chattel or an object that gets thrown in the kitchen junk drawer. I told you from the start, you don't have to choose who did what. They are each party to the crime of each other. They are parties to each other's crimes. And there is no doubt that 2-year-old Carter was murdered. He was murdered by the two people who were supposed to care for him. Now, I get 2 opportunities to talk to you. So I get this opportunity, and then the defense is going to get to talk to you, and then I get to come back. At this point, I kind of want to walk you through the indictment, because there's a lot going on, so I want to take it charge by charge. So count 1 is malice murder, all right? Now, the defense pointed out something, I think when talking about malice murder, it's murder that involved premeditation. Premeditation is not an element of malice murder. Malice can be formed in an instant, a depraved heart. It's an intentional killing of another without justification. And what you had in this case was testimony from the medical examiner who performed the autopsy, as well as the former chief medical examiner. Evidence of those injuries of the child, right? Not one bruise, there were multiple injuries to his abdomen and a hemorrhage in his brain. He had an injury to his groin area, his scrotum, both external and internal. Right? These repeated strikes are malice. That is what malice is. They are repeated, they are intentional, and on a 2-year-old child, they are 100% a depraved heart. This was not an accident. Count 2 is felony murder. It's based on cruelty to children in the first degree. So this felony murder doesn't require malice. All it requires is the intentional committal of cruelty to children in the first degree, which then caused the death of Carter. All right? Cruelty to children in the first degree is the intentional infliction of pain on a child under the age of 18. All right? It caused the death of Carter Ambrose. Again, the injuries, the repeated blows on that child. Count 3 is the cruelty to children in the first degree count. Intentionally causes cruel physical pain to a child under the age of 18. Count 4 is felony murder. This is based on aggravated assault. An object which, when used offensively, is likely to result in serious bodily injury or death, caused the death of Carter Ambrose. All right, now in that indictment, and I didn't hide this from you from the beginning, the exact nature of the object being unknown to the grand jurors. And I told you I didn't hide the ball from you. You're going to have some questions. You may have some questions. What object was used? All right, all it has to be is an object, and you look at the nature of the object, how it was used, whether it's a baseball bat or a fist, all right, likely to result in serious bodily injury or death. Count 5 is the aggravated assault, which underlines the felony murder that I just outlined for you. Count 6 is murder in the second degree. Murder in the second degree is based on a negligence theory. Again, malice is not required. The only count that malice is required is the malice murder. Murder 2 does not. It operates differently. It's a negligence standard. All right? So here, the negligence caused cruel and excessive physical pain to Carter when he has a lacerated liver and has been sick all weekend and nobody gives him medical attention. That is the negligence. He should have gone to the doctor before Tuesday. And cruelty to children in the second degree. Criminal negligence, which I'll define for you. A failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the failure to act. As the moments, as the hours ticked by, Carter slowly died. So remember the timeline. His time of death was November 17th, 2020. It was in the mid-morning. Time of injury. Time of injury was 24 hours before he died. So that was Monday morning. All the way up to 72 hours after that, which was Saturday morning. Remember the timeline. Sunday was when Carter was not fine. There's a couple other things I want to point out legally for you. One is the statute of limitations. So there's dates in the indictment. They don't actually mean a whole lot. All the state has to do is prove to you that this crime was committed on a day within the statute of limitations. So it's easy on murder because there isn't. All right? As it relates to the felonies, so you've got the aggravated assault, cruelty to children, second degree, all right, and a couple of the other ones. It's a 4-year statute of limitations. All right? So this happened November 17th. The indictment was towards the end of 2023. So it was November 17th, 2020. Indictment was in 2023. On my count, we're at 3 years, not 4 years. And remember, prosecution doesn't commence at the start of trial. It commences at the time of indictment. So this indictment, regardless of the time frame complaining, was returned timely. Other issue that I want to point out, and I don't know, it really hasn't come up at this point or not, but the judge is going to read a bunch of the law to you, and in that is venue. You have to try a case where the crime was committed, usually. So in this case, the injury was inflicted in the apartment in Houston County. You were wondering why we kept asking, is that in Houston County? Because that is an element of the crime that the state has to prove. All right? This apartment complex is in Houston County. That is where Carter was from Saturday evening all the way until he was rushed to the hospital. During that whole time frame, it's all in Houston County. So I don't want you to get caught up by that. Thursday was the last day Kadeem saw his son alive. He was a 2-year-old boy on a bike. drops him off at daycare, happy and uninjured. You'll never see Carter again, MF. Those were her words. Boy, how true are they? Friday, he's at daycare. He's happy. He doesn't seem injured. He eats his food. He wasn't throwing up. And the defendant picks him up. Saturday, takes him to granddad's house. He's happy, playing. He's uninjured. He's not throwing up. And then the defendant has Carter by herself for the rest of the day, Saturday, as well as most of the day, Sunday. And during the day, he's fine. She's the only person who has him. Boyfriend comes over, they have dinner, and that's when Carter is complaining of stomach pain at bedtime. And in her first interview with Sergeant Collins, she says that's when he was throwing up. It's not till the second interview that she changes her story. She moves it out to when she didn't have access to him. But that Monday, Carter is sick in bed at early morning hours. She goes to work. Boyfriend stays home with him all day Monday. Carter's throwing up again. Throws up overnight. He's complaining of stomach pain. Then Tuesday morning is when he's rushed to primary pediatrics. She drives out of her apartment complex within yards of the doctor's office and continues on her day, leaving Kianna to deal with her dying child. Again, you don't have to decide who did it. You don't have to pick one or the other. It's not all or nothing. All right? These two people had access to this child when he was symptomatic, the only two. Everybody else who came into contact with this child leading up to Saturday evening said that boy was happy. He wasn't throwing up. Carter never said, never told the defendant that Kianna did it. He would run to me and point and tell me who hit it. He didn't do that. He didn't do that. And she doesn't know what's going on. She didn't know nothing about anything. She is not particularly worthy of belief. She changes her story. After the fact, she's making up reasons for how it happened. She's bringing up that he fell, maybe on the couch or the bed, fell in the bed, rolled back and hit his head. She's asking about CPR when Lieutenant Meadows is talking to her. There's a lot to do about asthma, underlying conditions. He was sickly. You heard those medical examiners. There was no underlying disease. His lungs looked fine. What he had was a 2-inch tear of his liver brought on by blunt force impact. And to claim that she doesn't know. I call 30 million times a day. I FaceTime. I always check in when someone else has my child. And she's right there. She's right there. The time frame for the injury, when it was inflicted, right, is the closest to the time of death is Monday morning. So if you go back, she's the one who was right there with him the whole time. And according to her, she watches him like a hawk. I mean, she calls him a crybaby. He's dramatic. What a way to talk about your son. Whose autopsy photos have just been shown to the world. You never see Carter again. And then, once the injury's been inflicted, she calls Kadeem. Because he's EMS. And he doesn't come get the child. Boy, does he regret that. I can't imagine having to carry that guilt. I cannot imagine. So she leaves him with Kianna. Because she's a single mother. What else am I supposed to do? And lets him deal with the problem. she left him hold the bag, but then doesn't blame him, which is a bit odd. Rather, according to Kadeem, the man that she wanted to take the child because he was sick, wanted Carter to go with him, when he discusses with her the autopsy report and injuries of the child, and if he finds out Keon did something, he doesn't know what he'll do, she gets mad at him. She gets mad at a father grieving the death of his son for having the audacity to suggest that Keon did this. Now, I think I brought it up in my opening originally, and that is reasonable doubt. You're going to hear beyond a reasonable doubt. The judge is going to instruct you on that. I spoke about it with y'all a little bit on Monday in my opening statement, and I like to think of it as pieces to the puzzle. Yes, this is a circumstantial case. I told you from the beginning we didn't have an eyewitness. There's no CSI Miami, 1 hour, DNA, solve the crime, let's go home. It's all circumstantial, but there are plenty of pieces to this puzzle. First one is that the defendant and her boyfriend are the only ones with custody even at the outset of the symptoms. She changes her story. Her second interview, she tries to point her story away from herself. She doesn't go as far as to blame Keon, but she starts to build her own timeline. She's never blamed Keon. She's even defended him. She calls him 30 million times a day. And let's not ignore the fact that this is a substantial injury. This is a 2-year-old boy with a lacerated liver, a 2-inch laceration. But that's not the only injury he has. He has multiple injuries, including to his groin area, his scrotum. And he's a crybaby. He cries over everything. That's what the defendant says. You're not going to sit here and expect me to believe that this child was not in serious pain. A 2-inch laceration of the liver, and that it was just a minor tummy ache. There's no chance of that. You're not going to tell me this child wasn't in the fetal position, holding that stomach, rocking back and forth with a lacerated liver. And that's why Kadeem couldn't see his child. That's why he couldn't FaceTime or talk to that boy. Because remember, she's mad, she blocks him. He said it happens sometimes, but she's never refused him access to the child until the weekend his liver is lacerated. I have serious questions as to whether or not providing the child, letting Carter go with his father or leaving him home with Keon was not set up to point this somewhere else. She tells others it's because Carter fell. And she doesn't tell the police that, but she tells daycare workers that. She tells Gazette that. Building this story. How could this have happened? And then she bragged about the investigator, which is kind of an odd thing to do. And then when she testified, she couldn't even say Carter's name. Now this isn't the only time I'm going to speak to you. I'm going to speak to you again. I'll have more to say. But this is not an accident. This is cold-blooded hate, murder, malice, depravity. No child should die like this. Thank you.
Mr. Groove, there with you?
Thank you, Your Honor. May it please the court. Mr. Dwayne, Ms. Holland. Ladies and gentlemen of the jury, good afternoon. Once again, I'm Jeff Groove here representing Ms. Davis in this matter. I'm not going to whisper to you. I may do a little shouting. But I want everyone to hear what I have to say about this. Okay? First of all, Ms. Davis, thanks you for your service. She understands how traumatic of a case this really is. And it is. It's a sad case, as you'll ever want to hear. I'm going to talk to you for a bit, and Mr. Dwayne can come back up. and I don't have a chance to say anything else to you. This is it for me. After Mr. Dwayne finishes the next time, then the judge will instruct you as to what the law is. And it's very important that you listen to what the law is. They're called jury instructions. And the judge is going to talk to you, about what the law is, and I may go over some of that with you. But what I want you to first understand, or to also understand, is you will have a copy of the indictment with you, where you yourself will get to read the indictment. And of course, the judge has read it, and we've heard all about it, and it's important. It's important that you pay close attention to the language of all of the counts in the indictment. First of all, understand, and I'm glad Mr. Dwayne mentioned that the statute of limitations on some offenses is 4 years. As we know, this offense, the child died, Carter died, on November the 17th of 2020. That's when COVID was going on, if you remember. Okay? This case was indicted by the Houston County Grand Jury on October the 18th of 2023, almost 3 years later. And of course the state will say, we returned this indictment, it was returned within 4 years. Okay? But think about it. 3 years later, here we are, July of 2026, the case is finally going to trial. And you have to think, why? Okay? Of course, the state can get up and argue that they did everything they're supposed to do, and, the fact that the sheriff's department did their thing, and then it was submitted to us, and, it was the grand jury that didn't return the indictment until October of 2023. But in any event, timelines are always important in everything, in life, okay? In everything we do. And like I say, you need to be mindful of the fact that here we are, some 6 years later, after the child has died, that this case is going to trial. Okay? Now, you'll have this indictment, and I want you to read over it. Read over it carefully. And the state has to prove all of these charges against Ms. Davis beyond a reasonable doubt. And that's part of what the judge will explain to you is what does reasonable doubt mean? What does it mean? And the judge will tell you what that means. She's not going to tell you that it means down to a specific number or to a mathematical certainty. She will tell you as reasonable doubt means exactly the type of evidence that you need to consider when making your decision as to whether or not the state has proved each and every essential element of each crime charged beyond a reasonable doubt. All I ask you to do is, of course, you've heard the evidence, is follow what the judge tells you. Just follow what she says. And she will tell you what the law is. The first charge, as Mr. Dwayne has said, deals with malice murder, malice aforethought. And I think Mr. Dwayne was, I guess he was saying, when he was telling you that my client beat this child to death. Beat this child to death. And the judge will explain to you what malice aforethought means. She'll explain that to you. But that's what the state is alleging in count one, that Miss Davis beat her own child to death. And of course the state has said that they don't have any eyewitnesses or any factual evidence or direct evidence of that nature, that it's all circumstantial. And the judge will tell you the difference between direct and circumstantial evidence and what can be used. We understand that. But the burden is on the government to prove the charges as to malice murder. Malice murder is in our way of doing business in the state, that's the most serious offense that the state can charge somebody with. For beating someone to death. I mean, you see malice murder in cases where someone's been shot or been pistol whipped, or, I mean, and the state has said that they have no theory on what sort of weapon there was. Not that they have to, but they don't have that. So, I guess, you've seen Miss Davis in trial this week, and you've seen her testifying, and they're saying that either she did it maliciously, with malice aforethought, and they've also got Keon Benton charged with the same thing. He's not here. He's not here. Of course, they're being tried separate, but if he was there when this happened, then why is he not here to testify against Miss Davis? Because it didn't happen. Malice murder. Most serious of any murder that there could be in our state. The other charges, 2 and 3, felony murder with the separate predicate offense being cruelty to children in the first degree. And then count 4, felony murder, the predicate offense being count 5, aggravated assault. And of course the indictment here says in felony murder that the child was beaten with an object, the exact nature of which is unknown to the grand jury, caused cruel physical pain, that being a lacerated liver to the victim. Well, circumstantial evidence is what they've established. And circumstantial can be okay. Not in this case. Aggravated assault being circumstantial evidence that the child was struck by an object unknown to the grand jury. Okay. See, you sort of need to break down you either have a malice murder, you have a felony murder with these underlying predicate offenses, or you have what's in 5 and 6, which is an unusual charge in our state, but it's a valid charge of murder in the second degree. And you'll need to read the indictment on this one, that murder in the second degree occurs irrespective of malice, meaning there doesn't have to be malice. You have to show, or the state has to show, that they have established that the child suffered cruel physical pain by the failure of the mother to seek immediate medical attention. There has to be criminal negligence there. Criminal negligence. In other words, the state says something about wanton disregard or just not just failure to act, but intended to act that way. And I submit to you, ladies and gentlemen of the jury, that they have not done that. They have not done that. I'm telling you, Miss Davis is guilty of nothing. Now, once again, the burden of proof is always on the government to prove these charges, all of these charges, beyond a reasonable doubt. I'm not going to, and I don't know what Mr. Dwayne's going to do because he goes after me. That's the way this works. But you heard the evidence in this case. And as things go, a case of 3 days in a murder case is not that long. But still what's important is what you gathered or what you gleaned from the witness stand. Okay? You heard, let me mention this. Timelines are important, as I mentioned before. Miss Davis and Mr. Ambrose together conceived this child, and this child was born, as we talked about, on January the 14th of 2018. So 9 months prior to the child being born, Miss Davis became pregnant with Mr. Ambrose's child. Okay, and during that time, they moved in together at an apartment over at Sandpiper Apartments in Warner Robins. Okay, Mr. Ambrose was working at the fire department as a firefighter and EMS. He was doing that. And you heard Miss Davis testify that she was, she was taking classes, and she had worked some at FedEx and then worked at at a place in Macon, a dermatology place. And that the child was born January, like I say, January the 14th of 2018, while they were still living at Sandpiper Apartments. That they continued to live there, and you heard the testimony from Ms. Davis that, I don't think I'm being derogatory by saying that the child was somewhat sickly, okay? I mean, there's some things that we've said about sickly, and the state wants to be critical of Ms. Davis because she called her child a crybaby. I mean, so what? So anyways, the child was born January of 2018. The relationship between Ms. Davis and Mr. Ambrose continued on until March or so of 2020, when it just ended. And by then they were living over there at Lakeview Road Apartments, whatever the name of those apartments are. But it's important to note that these apartments are right next door to this pediatric place. And you heard Ms. Davis testify that that's one of the reasons why she moved over there, so she would be near where her doctors were for the child. And you'll have, and the state put into evidence, and you'll get these. The state's Exhibit 1, more than 40 pages of documents from when Carter started going over there to the pediatric place. And y'all can look at it yourself. The state put it in there for you to look at. I mean, Miss Davis isn't being disingenuous or dishonest with you by saying that she was over there at the doctor's office quite a bit. She was concerned about her child. Okay? I mean, all these instances of her taking the child to the doctor. And the state wants to come here and say that she's wanton and willfully disregarded the life of her child. That doesn't make any sense, folks. Doesn't make any sense at all. Now, one thing that is important to understand too is that Miss Davis is raising this child as a single mother. You've heard some testimony that, for the most part, her and the father, Mr. Ambrose, got along okay, and they agreed on the amount of child support to be paid, and that he was paying it. And then at some point in time, the decision was made, October or so, right, the month or so before the child died, that maybe he needed to be under a child support order. I mean, that's just, a lot of times the state will want to bring up things sort of like a red herring or a smoke screen or something to try to take your eye off the prize. Okay? And you can take it for whatever it's worth, any sort of problems that Miss Davis and Mr. Ambrose were having with each other, in the day or so before the child died. You can do whatever you want to with that, okay? I mean, if, there's some reference to a text that was sent by Miss Davis and the F word was used. Okay. We've never heard that before. Okay? I mean, I guess that makes Miss Davis the worst person in the world to use the F word in a communication with the father of the child. Making a mountain out of a molehill. So I think the evidence was that, I'm not going to go back through all the days before the child passed. Y'all heard all that. And we didn't go over when Ms. Davis testified today because the state put up the videos, the video interviews that she had with Sergeant Collins on the day after the child passed, and then, about 2 or 3 weeks later. Okay? Y'all got to hear all that. I mean, that's as raw emotion as you can get. Okay? And I guess the state's going to say that she was just putting on or making it up, but she didn't care about her child, and therefore the indifference or the criminal negligence, therefore at least murder in the second degree. And folks, that's for you to decide, not for me to decide, not from what Mr. Dwayne said. See, what I say is not evidence. What he says is not evidence. You have to decide the facts and the truth. We'll never know what the truth is. No one will ever know what the truth is. Other things that you need to be mindful of too, and I appreciate the attention. The set of facts in this case is just different. You heard that Ms. Davis, in her job, she worked for the Central Georgia Technical College, and she was assigned or sent to different high schools in the area to help them with their computer science classes. Okay? And you heard her testimony that she received a bachelor's degree from Mercer and also a master's degree from Mercer. Okay. And the way that the facts happened in this case, that she had gone to work up in Jones County or in Milledgeville on that particular ill-fated Tuesday. And that she had been trying to get in touch with Mr. Benton. Finally got in touch with him and they FaceTimed each other. You've heard all that. There's no sense in me going back over it. And so Mr. Benton put the child in the car and drove 2 or 3 minutes to the pediatric place for an emergency like this. And then basically the whole time Miss Davis was on the phone with Mr. Benton, and she even heard some of the conversation when she got into the pediatric place. I don't know if it was Miss Ledge or Miss Baker or Miss Gaddy, whoever it was, that Miss Davis recognized that there was a problem and she had to get back. Okay? And I'm grateful that all the folks from, or those folks from the primary pediatrics came and testified and told you what they heard or what they did. I appreciate that. And apparently they did what they could to try to save the child's life. Okay? But at some point in time, the doctors there, Dr. Ford or whoever, recognized that they wouldn't be able to, that they needed to get someone else that called 911 and get someone, and you heard the rest of it. Okay? And like I say, you also heard from Lisa James, who was over at the Peach County Emergency Room, and she testified that the child was unresponsive. And she said what she observed. And you can remember for yourself what she observed. And also the others that testified from the pediatric place, what they observed. But once again, you'll have all the documents from the place for way on back, for when the child first started needing medical treatment. Okay? Now, what's important to note is that, after Carter had passed, and Miss Davis and Mr. Benton went back to the apartment, and Officer Wartell from the Warner Robins Police Department was there. And you heard their conversation. Once again, their conversation with Ms. Davis and also with Mr. Benton was important for you to see. once again, raw emotion at its highest, okay? And we're grateful to Officer Boytel for being there to offer the comfort that he did. That's important to know. Trust me, it's important to know. And you know, they were waiting, Miss Davis was waiting on Sergeant Collins to come back so he could search the place. And if you remember, he hand wrote or prepared a consent form where Miss Davis consented to let Sergeant Collins with the Sheriff's Department, go in and search and look at everything in the apartment without any restrictions or just go in there and do it. Okay, you heard the testimony from Officer Herrera or Investigator Herrera, and you'll have with you State's Exhibits 15 through 61, I believe. All these photographs that we looked at the other day. And you'll have them back there to look at. Okay? All right? And you saw where there were certain places where it looked like, excuse me, that the child had either thrown up or vomited or spilled some of his orange juice or whatever it was. You'll have all those pictures. And you heard Investigator Herrera testify that he took samples from the carpet, cut out samples from the carpet or from the bed or from the pillow. Have any of them been shown to you afterwards? Folks, after Investigator Herrera took all that information, or all those samples, or whatever it was, he took them back to the Warner Robins Police Department and put them in a vault, and nothing was ever done with them. And what does that matter? Well, I mean, if you're investigating the case from law enforcement, and you're getting a pile of stuff to look at to see as to whether or not there's blood there, or if there's actually, to determine what you find, then do something with it. Did they ever submit anything to the GBI? No, they didn't. You heard Sergeant Collins testify that he left in February. He didn't do anything with any of that. And Lieutenant Meadows testified he didn't do anything with it. Well, who else would do something with it? Now, Mr. Dwayne said that there's been some things that have been a little odd. That was odd. You go to all that trouble, 2, 3, 4 hours, however long Investigator Herrera was there, and collected all this stuff, and then didn't do anything with it. That proves nothing. Nothing. Proves nothing. And like I say, folks, you can look at these pictures, and of course they're just duplications. You saw one from one angle, one from another, and one that had something that was like a measuring stick or something. You got to figure out if it means anything, or just a waste of time. Once again, this child passed away on November the 17th of 2020, and within a day or two, Dr. Brown, who granted his part-time and lives in Ohio and comes down here periodically to do autopsies, did the autopsy and gave a report, and he testified as to his report. Okay? And that Dr. Eisenstadt, who was his superior person there in that department, I guess he was called upon because there was such a delay in the report being completed that he got involved, and you heard all about the Zoom meeting that Dr. Eisenstadt and the other doctors and the DA's office and the Sheriff's Department all had, and came up to the conclusion that this is a homicide. And that report was issued 10, 11 months later. Okay? All the while, the testimony from Ms. Davis was she was calling the Sheriff's Department trying to find out what was going on with the death of her child. Nothing. Crickets. she got, crickets. And you know, at some point in time, the doctor finished the autopsy report after there had been peer review by Dr. Eisenstadt, and within a couple of days they finished the report, and then 6 weeks or so later they sent it to the sheriff's office, and by that time Lieutenant Meadows had the file and was working on it, okay? So, I mean, really nothing else was being done on it, and Lieutenant Meadows calls Miss Davis. She's up in Gwinnett County teaching school up there, Peachtree Ridge High School, and says, can you come down here? We've got some other information to give you. And of course they go over all that, and you saw the video. And of course Miss Davis, questioning what happened to her son, asked for a copy of that. Did Lieutenant Meadows go, no, we give her a copy. What's he hiding? Give it to him. I mean, what's wrong with taking the report, putting it in a Xerox machine, and giving it to Miss Davis? And then you heard the statement that Lieutenant Meadows said that, I'm not going to give it to you. And I don't know if we're even going to give it to your lawyer. And of course the state can speak to that, but you can remember what you heard. You know, what are they hiding? Why is it taking so long? So anyways, there that is. When Lieutenant Meadows had his conversation with Miss Davis, it's December of 2021. I guess Lieutenant Meadows sends everything to the district attorney's office, and that case is there for 2 years before it gets indicted by the grand jury. And the state may say, no harm, no foul. I mean, the whole time you've got a grieving mother here, and I think we can all agree that people grieve in a different way. I'm not going to make fun of anybody for grieving the way that they grieve. But here it is, basically 3 years after the child dies, the case gets indicted by the grand jury, and Miss Davis gets arrested then. 3 years. October or so of 2023. Here we are almost another 3 years later when we get here. Okay? And the state would have you believe, don't worry about it, nothing to it. Folks, there is something to it. That's for you to decide if that's something that you'll tolerate as citizens of this county. Once again, the burden of proof is always on the government to prove the charges beyond a reasonable doubt. Okay? And I don't mean to bore you with what I'm saying. Okay? You know, there's, the way that I was raised, if there flies on something, then there's a problem. Okay? And there's flies all over this. You know, and of course, the state, and I appreciate Mr. Ambrose being here, and I can appreciate, you know, I think the state was concerned. That's why they brought Ms. Tharp in, who babysat the child, saying that there's nothing that happened to the child, and they wanted to. You know, the Dr. Eisenstadt and other doctors say that the death occurred within 24 to 72 hours of the attack or the beating of the child. How do we know? I mean, there's no way, as a lawyer, that I can match medical wits, if you would, or medical knowledge with the doctor, the pathologist who did the autopsy, and then the one who was his supervisor that approved it. How can I match wits with that? I'm just asking simple questions and making simple statements. But the state, in trying to prove their case, has to always try to put a wedge. You know, that's why they brought Ms. Tharp in and bringing all this up about, I mean, you know, what is, I mean, Ms. Davis is grateful that Ms. Tharp made a pillow with the child's picture on it or a t-shirt or something. She's grateful for that. But why make it into something that it's not? Folks, we will never, ever know what happened. We'll never know. And I'm almost through. Let me just say this. Of course, Mr. Kennedy came in. That's Miss Davis's grandfather. Nice old guy. Nice old guy. And Miss Davis lives with him. He's taken her in. But you know, I mean, it's been 5.5, 6 years that his grandson has died. He doesn't remember everything. I mean, folks, he's a nice guy. I mean, but I'm glad he was here. You know, once again, after all that, you heard from the police officers in this, and you can take whatever you want to determine the guilt or innocence of Miss Davis. I mean, you know, we understand what Heath Collins had to say. He had the case, and he worked it pretty strong, I guess, for a couple, 2 or 3 months, and then he left. And I submit to you, the case just sort of sat there. You know, there was some talk about, from Dr. Eisenstadt or the other doctor, Dr. Brown, that did the autopsy, about whether or not it was homicide. But you know, the word homicide kept coming up, but also the word undetermined kept coming up. If they had decided that it was a homicide a month or so after the child died, and they got the reports back on toxicology and these other reports that you heard mentioned from the GBI, why didn't they do something then? You know, Sergeant Collins leaves, Lieutenant Meadows picks it up, and really nothing is done with it until the Sheriff's Department says they're waiting for a final autopsy report. Okay. I think we've all been around a little bit and know when someone's trying to pass the buck from one to the other. Okay? So anyways, the decision is made, as I mentioned before, and I'm going to be finishing in just a short bit, Jay, that Lieutenant Meadows gets Miss Davis in her office in December of 2021, and at that time he determines that she's a suspect. You know, but he takes a statement from her, doesn't give her Miranda rights or anything, because she's not in custody. That's the golden ticket there. She's not in custody. But that she's a suspect in his mind, but he just goes ahead and tries to clean up some questions that he may have from the previous interviews that she had with Sergeant Collins. And then for another almost 2 years, nothing else is done. The whole while Miss Davis is up in Gwinnett County teaching school at Peachtree High School, and then she mentioned the other school that she helped open up, a brand new school up in Gwinnett County with computer science. Okay? And then at the point in time where they arrest her, I mean, she's out of work. I mean, she can't. I mean, once she's charged with this, I mean, she's out of work. And so she's waiting. And she appreciates your patience in being here. She appreciates the attention that you've given to her in this case. And like I say, if there's anything that I've done that I've said, hold that against me, don't hold it against her. I'm just trying to help her the best I know how. You know, I'm getting ready to sit down, and the district attorney's going to get to come up, and I don't know how much longer he's going to go, but you know, you'll have all these photographs, all these documents, and you have to decide for yourself as to whether or not the state of Georgia has met its burden in proving these charges against my client. All these charges, beyond a reasonable doubt. If they haven't, then she should be found not guilty or acquitted of these charges. It's sad that this child is gone. Miss Davis' only child. Okay? You know, almost leave you with this one thing. I've tried cases down here for a long time, and I always tell people that don't leave your good common horse sense at those doors when you come through to serve. The judge is going to give you the law. You heard what the state has put up. You've heard Ms. Davis as she's testified. But use your own sense in making a decision about this. Follow the law. Follow the facts. And when you get back there, we would ask you to find Ms. Davis not guilty of these charges. And we thank you for your time.
Mr. Dwayne, your repeat.
Stop emailing me. Now you can't get or talk to Carter. Leave me the F alone, and that's the last time I'm going to tell you. Never to talk to his child again.
We'll never know what happened.
Is that really true? Quarter-inch rectangular red abrasion on the right external nair. Quarter-inch square red abrasion on the lateral aspect of the right upper lip. 1/8 inch irregular red abrasion on the lateral aspect of the left upper lip. Oblong red contusion to his cheek. Red contusion on the right chest adjacent to the sternum. 1 inch round red contusion on the midline upper abdomen along the costal margins of the ribs. 3/4 inch round red contusion on the right upper abdomen along the costal margin. Another separate distinct injury along the cage ends. Blue-green discoloration on the midline abdomen. Red contusion on the abdomen overlying the umbilicus. 1/4 inch round squared red abrasions on the underside of the scrotum. Red abrasions on the right mid-abdomen. Internal hemorrhages reflected on the scalp. Right posterior parietal. And then another one. Multiple. Interior abdominal wall muscles, adipose tissue, and mesentery. Extensive hemorrhage. 2 1/2 inch gaping laceration of the liver, the attachment of falciform ligament. Blood in the abdominal cavity. Pancreas hemorrhage. Testicle and cord hemorrhage. Patchy serosol congestion hemorrhage on the small intestine. But we'll never know. The medical examiners told you exactly what you needed to know. And Mr. Groove is absolutely right. You don't leave your common sense at the door. It stays with you. And common sense is that Kianna denies doing it herself, but she doesn't blame Keon. She defended him. And those are the only two people who had access to this child when the trained expert medical chief examiner tells you that this injury could have occurred. And her original statement that he had throwing up on Sunday night, not Monday, not a convenient change in her story to Monday when Keon was home with him, but Sunday, when it was her or Keon who had access to him. Common sense. It was either one or the other or both. And her testimony was really telling. Her evasiveness, confrontational, the fact that she wouldn't even say her own child's name. This poor mother who's lost her only child, and she can't say his name in front of you. She just didn't know. She's just oblivious. She had no idea. She didn't think anything was wrong, but yet she claims that she moved to those apartments to be closer to the doctor because he has asthma and allergies, like a whole lot of other kids do. in that she's always paying attention when something's wrong. And that she calls 30 million times a day. All of that vanished that weekend. And that's exactly why she wouldn't let Kadeem see her son. His son. Their son. Now, it has become apparent to me that the defendant's main argument as to why she didn't do this is because she's had to wait too long. That's the only consistent argument that has been made. Not about the facts as to what happened to that child. There's just been argument after argument about how long it's taken the state to get this to trial without offering any real context to it. Without offering any reasons why. If there were any other issues that came up beyond the state's control. Doesn't bother bringing anything like that up. But justice has no expiration date. Carter's life had the expiration date. But this trial does not. You want a smoke screen? There it is. That's their smoke screen. Be mad at the state. Don't be mad at the two people who had custody of this child when he suffered a 2-inch laceration to his liver. Don't pay attention to that. It just took too long. That's not even what the law says. Reasonable doubt. The judge is going to tell you it's not a fanciful doubt. It's not to a mathematical degree of certainty that the state has to prove this. Alright, this is where your common sense comes into play. You did bring up motive. The state doesn't have to prove a motive. It's not a legal requirement. It is not a legal requirement that the state prove motive. Or premeditation, for that matter. And then they bring up the fact that Keon Benton isn't here. Well, I'm not the only person in this room with subpoena power. With the power to compel someone else to come in. So they. Don't know the weapon. Yeah, I mean, I thought that was pretty evident from the moment y'all were sitting out there when the judge read the indictment to you. That's no secret. What we have is hemorrhaging on the head. We have multiple blunt force impact injuries to the abdomen. It could be anything. It could be anything. And you don't even have to pick what it is. Hands are the most obvious, but you don't even have to make that decision. All it has to be is an object, the nature of which. And the nature of those injuries, it is clear that a hand or other object was used to inflict them. This defense argues murder too is weird. No, not really. Not if you think about it. Not if you think about what duty a parent has to their child. Their 2-year-old child. I'm not sure if there's legal duties as it relates to, children who are 30. But a 2-year-old who relies on his mother for protection. A woman who claims that she moved close to the doctor's office. Who said that throwing up in his sleep was a red flag or it was abnormal. But then in the same breath said she didn't think anything of it while she was lying to y'all on the stand. A woman who took her child to the pediatrician all the time, who had him hospitalized, who watched his allergies, who gave him his breathing treatments when he needed. The absence, randomly, of her give a damn is telling. Yes, when your 2-year-old child is in that much pain, you have a responsibility to seek medical care. And she did not do that. Reckless disregard for how the pain that he was experiencing may affect him. And we know waiting hurt. We heard that testimony from the medical examiner. It hurt bad. I think it hurt a lot worse than she was saying. I don't think there's any way he was letting on that this was just a little stomachache. And that caused pain and pain and more pain until he died. Whether or not you want to pick a winner and a loser, who did this, who didn't, other than Carter, who's the victim here and who's not. Whether or not she actually knew or didn't know. At a minimum, she's guilty of murder in the second degree for not performing her basic duty as a mother. Feed them. Give them some clothes. They don't have to be nice. Put some kind of shelter around them. Give them some medical care. She couldn't even meet that burden. But poor her, single mother, as though Kadeem was not an active father in this little boy's life. He didn't abandon her. Didn't cut ties. He wanted to be involved in his child's life. She took that from him. She testified. She lied. She lied. I asked her if she tried to get a new phone shortly after this. She said no. And then we went through pages of her trying to get her new phone. Records that she herself identified right after this happened. Multiple pages. Why suddenly do we need a new phone? To conceal. Why brag about the fact to Miss Shirley that the original investigator is no longer on the case? She's calling. She wants more info. More info. She's worried about herself. She knew that the arrow pointed to two people, and she was one of them. She's terrified that the state may come down on her. And then she testifies that if you call the pediatrician's office, you can't get an appointment the same day. That a pediatrician would never have the time. As though a pediatrician would never anticipate the fact that younger kids often get sick. Simple illnesses. But they can't just be seen. Oh, I gotta wait. I gotta wait. I can't get an appointment. Never mind the fact that she's a regular. Never mind the fact that she carried on and on and on about how awful it must be for them when she's on the body cam with Officer Whitell. She didn't even make an effort. Now they make an issue of the samples in the floor. They didn't send anything to GBI. Well, Carter's body went to GBI along with that liver, along with those bruises, those hemorrhages. And what is interesting is that all of a sudden here, well, we don't know if he was throwing up or not. When she herself tells law enforcement in one of her interviews, yeah, I figured out he was throwing up. And now she wants to change her story on that. Every little thing she wants to change. She wants to fight. The question here isn't whether or not you tolerate how long it came to trial. The question is whether or not you tolerate a 2-year-old boy being murdered. That's the question. You've heard quite a bit of testimony. Remember, testimony is evidence. You heard about what was overheard by the primary pediatrics people. Don't worry about that. Just get here. Or I should have brought him when you told me to. Not sure why Mom is telling somebody else. else who's not biological father if she's there, like she said she was. Another man who she broke up with shortly after this, she didn't want to answer that question. She didn't want to answer anything. In fact, when I said nothing further, Your Honor, she went, thank you. A grieving mother. Common sense here. Two people had access to this job. And she says she didn't do it and that Kianna didn't do it. Common sense tells you that statement makes no sense. They were hiding, covering up. Covering up. Whether she hit that child, whether he hit that child, at this point, it doesn't matter because one of them did it or both of them did it. But now we have to cover up. She wants you to believe that she's such a good mother that she calls all these times a day. She always checks in. She drives from the office at lunch to get, to check on Carter while he's there. And yet she's got no idea. No idea. Ladies and gentlemen, there are plenty of pieces to this puzzle for you to see that she is 100% guilty of malice murder, of felony murder, and murder in the second degree. Thank you.
All right, ladies and gentlemen, as you know, you are considering the case of the state of Georgia versus Kianna Davis. The grand jury has indicted this defendant for malice murder, felony murder, cruelty to children, felony murder, aggravated assault, murder in the second degree, and cruelty to children in the second degree. And the indictment reads as follows. It charges her in count 1 with malice murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of the offense being unknown to the grand jury, did unlawfully, with malice aforethought, cause the death of Carter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury. Count 2 charges her with felony murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of being unknown to the grand jury, while in the commission of the offense of cruelty to children in the first degree, a felony, did cause the death of Carter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury, which caused cruel physical pain, to wit a lacerated liver, and said victim is a child under the age of 18 years. Count 3 charges cruelty to children in the first degree. The said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date being unknown to the grand jury, did maliciously cause Carter Ambrose, a child under the age of 18 years, cruel physical pain by striking said child with an object, the exact nature of which is unknown to the grand jury, which caused a laceration to said child's liver. Count 4 is felony murder for that said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date of the offense being unknown to the grand jury, while in the commission of the offense of aggravated assault, a felony, did cause the death of Carter Ambrose, a human being, by striking said victim with an object, the exact nature of which is unknown to the grand jury, which when used offensively against the person is likely to result in serious bodily injury. Count 5 is aggravated assault for that said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date being of the offense being unknown to the grand jury, to make an assault on the person of Carter Ambrose with an object, the exact nature of which is unknown to the grand jury, an object which when used offensively against the person is likely to or does result in serious bodily injury by striking said victim with said object causing a laceration to the liver. Count 6 is murder in the second degree. The accused in the state of Georgia and the county of Houston on or between the 15th and 17th day of November 2020, the exact date being unknown to the grand jury, did commit the offense of murder in the second degree. The accused caused the death of Carter Ambrose, human being, irrespective of malice, while in the commission of cruelty to children in the second degree, by failing to seek immediate medical attention for said child for his lacerated liver. Count 7 is cruelty to children in the second degree, for that said accused in the state of Georgia and the county of Houston
between the 15th day of November 2020 and 17th day of November 2020, the exact date being unknown, with criminal negligence, caused the death of Carter Ambrose, a child under the age of 18 years. Cruel physical pain by failing to seek immediate medical attention for said child for his lacerated liver. All of these being contrary to the good order, peace, and dignity thereof. This indictment was returned by the House and County Grand Jury on the 17th of October 2023. Now, the defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you're to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove innocence or to introduce evidence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a doubt of a fair-minded, impartial juror who's honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it's a doubt for which a reason can be given, arising from a consideration of the evidence, the lack of evidence, or conflict in the evidence. After giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that's the doubt of the law, and you must acquit this defendant. But if such doubt does not exist in your mind as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of this defendant. Now, members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. Obviously, that's what I'm doing now. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence that's been presented. Then you must apply the law that I'm giving you in this charge to the facts as you find them to be. Your oath requires that you decide this case based on the evidence. Evidence is simply the means by which any fact that is put in issue is either established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits that were admitted during the trial. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or the questions asked by the attorneys, only the answers given by the witnesses. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions or reach conclusions. You should not be particularly concerned about whether the evidence is direct or circumstantial, but I am going to define those for you. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Now, as jurors, you must determine the credibility of witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you were able to observe it. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that's not common knowledge or known to the average citizen. The law permits witnesses to give their opinions based upon that training and experience. You're not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. To impeach a witness is to show that witness is unworthy of belief. A witness may be impeached by disproving the facts to which that witness testified. Your assessment of trial witnesses' credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for an inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, the jury must apply your common sense and reason to decide what testimony you will believe or what testimony you do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant has made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised. These statements were not given in custody, so you can disregard that last sentence. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under any compulsion or necessity imposed by others. Now, this defendant is charged with crimes against the laws of this state. A crime is simply a violation of a statute in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon consideration of the words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will. A person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. Now, you should know every party to a crime may be charged with and convicted of the commission of a crime. A person is directly a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of that crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of this defendant that the crimes alleged here were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that this defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help, or was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime charged here was being committed, and that the defendant knowingly, intentionally participated or helped in the commission of it, you would be authorized to convict. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in a criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Now, members of the jury, the law of our state sets a time limit upon the state in starting the prosecution of most criminal offenses. The accused is on trial for the offenses of murder, aggravated assault, cruelty to children in the first and second degree. Under Georgia law, there is no statute of limitations for any of the types of murder charged. However, prosecution for the offenses of aggravated assault, cruelty to children in the first degree, and cruelty to children in the second degree must begin within 4 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit this defendant. The law provides that criminal actions shall be tried in the county in which the crime was committed. We call that the venue. That's the crime was committed in Housing County. And that's a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue may be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. All right, let's talk about the specific charges. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be malice murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act of the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive that's been admitted for your use in determining the defendant's state of mind at the time of the killing. All right, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. So I want to define cruelty to children for you, and that would be the same definition for Count 2's felony murder portion and Count 3, which is the actual cruelty to children in the first degree. Okay, so I'm going to define that for you now. For cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Count 4 charges felony murder with aggravated assault as the underlying felony, and Count 5 is the aggravated assault. I'm going to define aggravated assault for both of those. And felony murder is the same, right? And it caused the death and commission of a felony. But in Counts 4 and 5, that underlying felony is aggravated assault, okay? Aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object charged here is an offensive weapon, you may consider all of the following factors. the nature and extent of any injury inflicted, the character and capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. Count 6 is murder in second degree. For murder in second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show that the defendant acted with malice in order to prove murder in the second degree. Cruelty to children in the second degree is the count number 7. I'm going to define that for you now, and that should also be the definition you use in considering count number 6, the murder in the second degree. Cruelty to children. For cruelty to children in the second degree, the state must prove that the defendant caused cruel physical pain to a child under 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the failure to act. Now, an accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no criminal scheme, criminal intent, or criminal negligence by this defendant. I want to define criminal negligence for you in this context. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by that failure to act. If the defendant raises a defense of accident, the state has the burden to disprove the accident beyond a reasonable doubt. All right. You must reach a verdict as to, let me try again. If after considering the testimony and the evidence produced to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Houston County, Georgia, did on or between November 15th through 17th of 2020 commit one, some, or all of the offenses as alleged in this indictment, then you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, as to whichever counts, find the defendant guilty. If you do not believe that the defendant is guilty of one, some, or any of these offenses as alleged, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant. In which event, the form of your verdict would be, we, the jury, as to whichever counts, find the defendant not guilty. A conviction on one count of the indictment does not require there be a conviction on other counts. It is the duty of the jury to consider each charge of the indictment separately. Now, by no ruling or comment that the court has made during the progress of this trial, have I intended to express any opinion on the facts of this case, the credibility of witnesses, the evidence, or the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence, according to the law given you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy to either side. You are only concerned with the guilt or innocence of the accused. You are not to concern yourself with punishment. That is an issue for the court in Georgia. Now, one of your first duties in the jury room will be to select one of your members to act as foreperson who will preside over your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another. Consider each other's views. Each of you must decide this case for yourself, but you should only do so after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous, that is agreed to by all 12. It must be in writing, signed, and by your foreperson, dated, and returned to be published in open court. All that means, y'all, is I'm going to give you a verdict form. You're going to circle your verdict, guilty or not guilty, as to each count. You'll give it to the bailiff. I'll read it out loud once you're ready to do that. I'm going to let you retire from the jury room in just a second. I'm going to ask you not to begin your deliberations until you receive the indictment, the verdict form, and the evidence that's been admitted. If you have questions during the deliberations, they should be written down on a piece of paper, signed by your foreperson. You flip the light, the bailiff will bring them to me, and I'll respond to those. We've been at it a while, so I know y'all are going to need a break before you start your deliberations. Here is, let me give you a caveat about that. You can talk about the case only when all 12 of you are in the room. So if somebody's outside smoking or somebody's in the bathroom, you have to stop talking about the case until all 12 of you are back.
So I'm gonna let you retire to the jury room, take a break, just a minute. Don't start deliberating until all 12 of you are back in there. I have 2 alternates in this case. That's gonna be Mr. Reuter, am I saying it right? Reuter, and, okay. So you guys will be in a separate room. You will not participate in deliberations unless that becomes necessary because one of the others cannot finish, okay? With that, y'all take a break, retire to the jury room, please. All right, objections to the charge from the state,
No, Your Honor.
from the defense.
No, ma'am, none.
All right, I am printing the verdict form. Y'all need to look at, no, hold on a second. Let me not do that. Ah. Here is the indictment. That needs to go down there. Y'all make sure you got all the pictures, nobody wandered off with anything, please.
Did you say that you were going to print the one that also had his plea?
I stuck it in there already,
Okay. This is, yeah.
right?
I couldn't remember if you said take it
I,
out.
no. I think it should have those in
That's
there.
fine.
Two.
So the videos will stay here. There should be the medical records and the photographs is all I've got, right? And the email.
That's all you're on.
All right, y'all want to look at this verdict form and make sure there's nothing swirly in there. I've got them numbered right and the right number, case number and stuff on there.
It's, yeah.
Watch this light. Okay.
We have a call with word form.
That's good.
All right, so put it on top of your stuff and give that to Mr. Davis, the indictment too. All right, Mr. Davis, you can take that. We'll stand in recess till we hear from counsel. Y'all make sure the bailiffs know where to find you. Because I suspect
We'll be back shortly.
that would be my guess with questions or request to review a video. But we'll see. Y'all be seated. All right, is that because we didn't turn the light off last time, or they got another question?
I believe it's the same light.
Okay. You ready? Okay, so we have a question from the jury. I am marking the written question. Number 1, it says, can we please be provided the definitions that were provided by the judge during the final instructions? I am assuming that they want the definitions for the charges specifically, but I need to ask that. So, counsel, what I'm going to do is, I'm going to send them a question back in writing that says, do you mean the definitions for the specific charges? And if they say yes, then I'll bring them out and recharge them on that. If they say no, then we'll figure out what they do mean. Okay?
Yes, ma'am, no objection.
Mr. Dwayne?
There's no objection to
Okay. Take that and just tell them to flip the light and answer for me. And we'll just sit right here because I'm 80% sure that's what they mean, but you know what they say about assuming, so I want to make sure I'm clear what they mean before we go. If that is what they want, then I will I'll readjust the charges and then remind them that they need to take that as part of the charge and consider all of the rest of the charge and reaching a verdict. There you go. Yes, the ones that explain malice, child cruelty, etc. So I'm going to recharge on malice murder, felony murder, aggravated assault, and the 2 cruelty charges. You can bring them in, please. Not. All right, I don't need the alternate. All right, ladies and gentlemen, y'all have asked to be recharged on the specific charges, the definitions of each charge, so I'm going to do that now. I just will remind you that you're hearing the portion that is specific to these counts, but also you should consider those in light of the entire charge when you get back in there, okay? All right, malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder, or to be malice murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing,
and moves the defendant to do it, that is enough for the killing to be malice murder. The state does not have to prove, excuse me. The state does not have to prove motive to prove murder. Any evidence of motive that has been admitted for your use in determining the defendant, let me try again, y'all. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. Cruelty to children in the first degree is a felony for which I'll define for you now. Cruelty to children in the first degree, state must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Count 4 charges felony murder with aggravated assault as the underlying felony. Aggravated assault is a felony which I'll define for you now. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, or any other circumstances of the case. Murder in the second degree. For murder in the second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show the defendant acted with malice to prove murder in the second degree. Let me define cruelty to children in the second degree for you now. For cruelty in the second degree, the state must prove that the defendant caused cruel physical pain to a child under the age of 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by this failure to act. All right. Take that with all of the other, I want to make sure I define criminal negligence. I did. Okay. So take that in accordance with all of the law that I've given you and facts as you find them to be, and I'll let you resume your deliberations. Thank you, ladies and gentlemen. My intention is, if we do not hear from them again by about 6, I will inquire if they want to continue or go home for the night. If they go home for the night, we're going to have to resume Friday morning, which is not ideal, but I cannot be here tomorrow. So we knew we were going to have to work around that. So we'll just wait until we hear from them.
Is there a judge, Your Honor, that could potentially take the verdict tomorrow?
No, I don't think that's a good idea. Because if we get questions or we get issues, that becomes more complicated. And I'm not sure Judge Smith or Judge Adams are available. But we'll see. Let's see where we are then. All right, we'll stand in recess till we hear further from them.
Y'all be seated. All right, we got everybody? Anything before we bring the jury in?
Not from the city. Nothing from us, really.
You bring them in.
Sound good. No.
Ladies and gentlemen, we are ready to resume. Mr. Collins, I remind you, you're still under oath. Go ahead, Mr. Dwayne.
Thank you, Your Honor. So last we were in here, we had watched at least part one of that second interview, right?
Yes, sir.
All right, and that interview was on December 7th of 2020?
That's correct.
Okay. Having done the first interview on November 18th.
That's correct.
And they work on that? House. Okay. So Kianna shows up. Okay. Anybody come over? Did you go anywhere?
I probably did. I've been back a week, so now.
How was his behavior, something?
Perfect fine.
Was that good?
Yeah.
Okay. There's no issue Sunday, was there any, nothing happened, no accidents happened, or said nothing you point out?
Just Saturday when his arm got swollen. You know, that was it.
Okay. And I was just out of the blue, nothing happened that you know what causes out of swelling?
No, because we had just been to the doctor about 2 weeks before that because he had a bag of chips and his whole face blew up. So, she said, when I was there, she told me that he could possibly have another early reaction later on. So I assumed that that was what she was saying is.
Okay. So, we're clear on, obviously Tuesday morning, we're clear on Monday night, clear on Monday, clear on Sunday. Saturday, the only place you went was Granddad's. He was in your supervision the whole time. Okay. Just real quick, Friday, what was Friday?
Friday I was to work, he was at daycare.
He was at daycare Friday. Okay. Where does he go?
He goes to daycare at a lady named Faye Park.
Faye Park? She got you for PD? Is that personal, it's not like daycare?
No, she has a at-home daycare.
On daycare? Okay. Where is that at?
Where are we supposed to
I'm sorry.
Right on the same road as Lawrence Middle School.
Do you have a phone number? So you have any company?
No, that address.
It's 478-213-9661.
What time was he there Friday?
He gets there at about 6:30 in the morning, typically.
And what time was he picked up Friday?
I pick him up at 6.
6 p.m.? Okay. And that's what happened Friday, there, 6:36. When you picked him up, was there any issues? Any complaints or anything going on then? He was fine all Friday night, he was fine all day Saturday, and all day Sunday? Okay. All right. Is there anything that we haven't talked about that you think is important?
Just not really from what happened, but I've been asking just for so long for allergy tests for everything because he's had episodes of throwing up all the time from regular milk to whatever, and we even been referred to a pulmonologist. We never got tested. So I've always had concerns that something, it was deeper than just a breathing issue that they were trying to tell me, because every time we go in, most of the time he's not sick. They test him for everything, and the breathing just happens. So.
Well, it doesn't, I don't believe this is due to any kind of allergy. Okay? I thought it was a medical exam. Okay? What they have, the initial right now, okay, is he had a lacerated liver. Okay, he had blood tapping. He had multiple contusions of his body. He had lacerations to his pancreas where it attaches to his body. Okay, there was no signs of any breathing issue that would cause his death. Okay. So, there was something that happened to him. There was some type of injury to his abdomen that caused this to his liver and the contusions to his body, some sort of impact.
There's nothing that literally, I mean, he's never had any issues with his stomach. Never been hit. Nothing.
They don't think this would be from a fall. Okay, so it's not from a fall, and it's just multiple impacts that cause the injuries, to the internal injuries. Okay. It's like, getting hit with stomach real hard.
You know what? He doesn't even hang out with the kids and take care.
Well, here's the other part of it, is that, I understand this is the Georgia Bureau of Investigation that does these autopsies. They're saying that whatever caused these injuries happened within 24 hours of his death.
Nothing.
Well, there's some things that could happen. There's things that had to happen. Something had to happen. You don't get this without something happening. So,
The child isn't even.
how does Mr. Benton, does he ever tell you
No. God.
about yourself? How do you know?
No. I don't even hit my child. That's literally part of everyone's issue is that
Who's
I'm
this?
disciplined. His fault. I'm too nice. He's 2. So there's no reason to discipline a 2-year-old when he's still learning.
Yeah. I mean, I'm with you, I understand. But something happened. And the only, right now, is you were around it, Mr. Benton was around it. And I mean, you go back far enough, Grandpa was around it. But you were supervising the whole time there, and that was well before 24 hours. Okay, pretty much he started getting sick, according to y'all, after lunch Monday. That's when his stomach started hurting, started throwing up. Okay. Who you been with between that time?
He's living with no one except for me. Thank you.
Okay. So the concern here, the obvious concern, okay, is that something's happened that either yourself or Mr. Benton are concerned to tell us.
God, no.
Okay.
If there was something I would tell you, and he would tell you.
Okay. Well, I hope so.
Nothing happened.
Well, something. There's something. We don't.
There's nothing in my house that he could even run into. To the extent that he would hit. He didn't even. The child learns about everything. So if he would have hit something, he would have came running to me. He would have cried. He didn't even cry. So.
Do you think there's any chance Mr. Benton struck him?
God, no. No. The child, I mean, no. There's just no way that it is off.
Well, I'll tell you, the only way to have a lacerated liver, multiple contusions of the bowel, a laceration to the pancreas, is from some sort of impact to that abdominal area. Okay?
No, if you're right mind. And you're talking about within 24 hours. Absolutely not. I call
How often do you call?
30 million times a day, especially if someone has my child. And
You
no one
call Mr. Denton every
Yes.
30 minutes on
I
that?
call him. Every chance I get, I'm calling. And it has nothing to do with anybody. It has just to do with me always wanting to be around Carter and wanting to talk to Carter. So,
Should it be like you, Dr. Smith, every 30 minutes on Monday?
not every 30 minutes on Monday, but I have classes, but
So I mean, it's important at this point that we know how often you talk to Mr. Benton on Monday. How often do you think you talk to him on Monday?
I call.
Well, let's go from that morning, because we know you come on Monday at lunch, around 11ish, is that right? That's 11, 7:15, back at 11ish. That's 4 hours.
I am on Robin, so I didn't leave at 7:15. I probably left at 7:45 because I was.
No, we had a video you leave.
Okay.
Okay. So, what, between that 7:15ish and 11:15ish, 11, did you call them? How many times did you call Mr. Benton that morning?
I don't know. I always
Do you call all of them that day?
know. There's really no way. There's no way no one could have ever touched my child. And that is no. No.
Wow. You changed your phone service?
No.
Okay. So, is your phone line and your phone service?
Yes.
Would you be willing to use your phone bill and show me? Because I'll need to know how often you call them that day.
We would have no issue. No, no.
Was there any change when you called them that they just sound different or?
No, like that's.
Because according to everything, really, it seems like something happened. I think it happened after lunch Monday, whatever it was. I think it happened after lunch Monday after you left. And then you went downhill from there.
What you're implying,
Now,
I said what you're implying, just is so bizarre, just because of who he is and who he has always been and who he
Always
always
been?
Yes, like he would never, like never. My child literally loves him. My child calls him dad. And he doesn't even do that. There's just no way. And if Carter didn't like somebody, or if Carter felt a certain way about somebody, he would definitely not be around them, and I wouldn't know, and I wouldn't even allow it. I don't let anybody watch him except for babysitter and me and dad. That's just what it is. And that's just because of his breathing issues. I don't trust people with him in that situation. So if I would never leave my child with him if I ever thought that he was even capable. The man is not even capable of hurting a fly. So
well, I mean, honestly, it seems like a pretty decent guy just from my university with him, okay, yourself. But these are the facts, okay? There is no me changing this.
the facts are, there was nothing wrong with my child. And if something was wrong with Carter, or if someone hit him, or whatever,
Okay.
he's a crybaby.
What was his vocabulary with you?
Who's Carter's?
Yes.
Mom, my stomach hurt.
So he could say that much everything?
He says, he can say it really, but he's not even to the point where he's like saying full wrong sentences. He can mix words together, but if something is wrong with him, he's gonna find, or he's gonna come to me and point and show me what happened, or show me who did it.
I'm gonna stop it right there, Judge. kind of stand clear of the file format on that one. Alright, so we watched all those videos are fair and accurate, representations of the interviews that you did with her.
Yes, sir, it is.
And after each of these interviews, she was free to leave.
Yes, sir.
So I want to point out, so in your interview with her that we just saw, you're working, you say, 24 hours. Okay, so this was December 7th of 2020, right?
Yes, sir.
And when did you end up leaving the sheriff's office?
February 21.
Okay. You aware that there was a big meeting between the chief medical examiner, the forensic pathologist that performed the autopsy, and other members of the sheriff's office, DA's office? Were you aware that any of that happened?
At a certain point, I was.
Okay, was it after the fact that it happened?
Yes.
Okay. But you weren't involved in that meeting?
No.
So at that time, you didn't have any information, really, other than what you've been provided, at least initially?
That's correct.
And at the time that you left the sheriff's office, you didn't have the final autopsy report?
No, I did not.
And the questions there, so you're asking about Kianna, right?
Yes, sir.
And that something happened, at least with the limited information that you had at that time, you're asking in the context of what was Kianna doing. Potentially this could have been, Monday afternoon after you left. What is the purpose of trying to bring Kianna up? What are you trying to accomplish?
Well, one of the things I'm trying to accomplish in this interview is to go to suspect list, a complete suspect list. I'm not sure anybody the child in contact with, or certainly 24 hours, but well beyond that, at least a day or two. That was one of my initial objectives.
Okay. And at that point in the interview, you got any information to indicate that any person had done anything? Nothing further this time around.
Mr. Bird, please review.
Thank you, Your Honor. Good morning. Is it still okay for me to call you Sergeant?
Sure.
Sergeant Collins, it's always good to see you.
Sure, thanks for you too.
Let me ask you several questions. Once again, you originally got the call, did you not, to go to the hospital, Peach County Hospital over in Byron, is that right?
Yes, sir, that's correct.
And by the time that you got over there, the child had already been pronounced deceased.
I believe that's correct.
Did you, was Ms. Davis there?
She was.
Okay, did you interview her then, or talk to her then?
I had a brief contact with her before leaving the hospital.
And was the contact that you had with her that she needed to go back to the apartment so somebody could walk through the apartment?
During our conversation, I asked her if I could meet her at the apartment after leaving the hospital.
And she did in fact comply with that?
Yes, sir.
And Mr. Benton was with her also, is that correct?
Yes, sir.
So it's well, let me ask you this: when the child was pronounced deceased, did you go with the child to the morgue at the hospital in Warner Robins?
I wasn't in the morgue. I went into the room where he was located.
Okay, but when the child was removed from or taken from the Peach County Hospital to go to the morgue in Warner Robins, is that right?
I'm not sure where the child went after the hospital. I was told by the coroner he would be going for autopsy to the GBI's office.
All right. So I take it that you left from the Peach County Hospital and then went to the apartment there on Lakeview. Is that correct?
Yes, sir.
And Ms. Davis was there with Mr. Benton. Is that correct?
Yes, sir.
And also Officer Boytel was there from Warner Robins. Is that correct?
Yes, sir.
And at that time, you talked to Ms. Davis to see about getting consent to search the inside of the apartment. Is that correct?
Yes, sir.
Did you search it then, or did you wait for Officer Herrera to come, or Investigator Herrera to come from Warner Robins?
I waited for the investigator.
All right. But in any event, you got Ms. Davis to sign a handwritten or makeshift, if you would, consent search, is that correct?
That's correct.
When the place was searched, was it just you and Investigator Herrera?
I don't recall who all was in the apartment. I believe it was one of the officers, maybe somebody assisted me, I'm not quite sure.
Okay. Do you recall seeing Meredith Edwards from the Warhouse Police Department over there?
No, sir.
Do you think it may have been Officer Woytel that went in to help search the place?
I'm not sure, sir.
Okay. Was the purpose of searching the apartment to clear it, or was it to gather evidence?
It was documents and
Documenting. And at any point in time, did you yourself gather evidence, or did you just watch Investigator Herrera do that?
I just observed. I did not collect evidence.
And did you stay there through the entire time that Investigator Herrera was photographing and collecting evidence? Did you stay the entire time?
Yes, sir, I believe I did.
Okay. And I take it that Investigator Herrera gathered quite a bit of evidence. In other words, pillows, and do you recall anything that he may have taken?
I don't know all specifics of this collection. I didn't observe each collection that he made.
Okay. And that was documented?
Yes, sir, they document each thing that they collect.
He would have done that just himself, or did you help him do that?
No, sir, he would have done that himself. I was not part of crime scene investigation.
In gathering that pillows, and do you know as well that he cut any of the carpet?
I do not know.
I mean, if he cut any of the carpet or taken samples from a carpet or bed mattress or anything of that nature, you would have seen that, would you not?
I was present, but I did not follow him around the entire time or help him collect him or anything of that nature.
In Investigator Herrera gathering this information, did he give it to you?
The evidence, the collection of
Right. So, to your knowledge, did he take it with him?
to my knowledge, yes, sir.
At this particular point in time, would you have been considered the chief law enforcement person investigating this case at that time?
At the time, I would have been assigned investigator.
Okay, and that would have been in conjunction with the Warhouse Police Department too, is that right?
Yes, sir.
The items that were gathered, I take it as standard protocol for law enforcement to take it back to their office and put it in an evidence vault, is that correct? Generally speaking.
Yes, sir.
Do you know if any of these items were ever turned over to you?
They were never turned over to me.
Okay, so I'm asking this question. Do you know if anything was turned over to the GBI?
I do not.
Okay, so you didn't do that, no? If anything was turned over to the GBI, that was not something that you did.
That I was involved in.
Do you know if anybody else from the Houston County Sheriff's Department did that?
I'm not sure, sir.
Now, you testified that you left the employ of Sheriff Talton in February of 2021, is that correct?
Yes, sir.
So at the time that you left the employ of the Sheriff's Department, to your knowledge, this case had not been taken to the grand jury in Houston County.
The time I left, sir, I was still waiting on, the sheriff's office still waiting on final autopsy results to report.
Now, you've testified that, who was it, as far as this information that you relayed to Ms. Davis in this interview of December the 7th of 2020 concerning the injuries to the child, who did you get that information from?
The injuries about the child.
Right.
I was informed by staff at the hospital of his condition coming in.
Okay. So, I mean, did you receive this information from Danny Galpin, who was the coroner at that time?
Danny Galpin was present when I was at the hospital, and I did receive information from him.
Okay, so you received from Danny Galpin.
I received information from different parties. So Danny Galvin provided information that he had, and then the staff at the hospital provided their information.
Was any of the information that you received in writing,
Not at that time.
or at any time did you receive anything in writing?
I had statements later.
I'm not talking about statements from people that worked at the, and I think, did you receive the written statements from all of the employees at the pediatric place?
Yes, sir.
Okay. Besides that, well, did you ever talk to the medical examiner, Dr. Brown?
From GBI,
Right.
I believe I had a brief conversation with him on the phone.
And once again, all this information that you received was before you left the sheriff's office in February of 2021. Is that right?
Yes, sir.
Okay. Who was it that you turned the file over to once you left?
My lieutenant.
Lieutenant Meadows.
Yes, sir.
And at that time, do you know as to whether or not any of the items that were collected from the apartment were ever sent to the crime lab, not necessarily by you, but by any law enforcement agency?
I don't know. It was in that time.
Now, we've watched these videos that you had with Miss Davis. Once again, one was on the day after, on the 18th of November, is that correct?
Yes, sir.
And the next one was done 3 weeks or so later, on the 7th of December, is that right?
Yes, sir.
In between the time of the first and the second one, Miss Davis had moved to the Atlanta area, is that right?
Yes, sir.
And once again, at no time did you ever advise her of Miranda rights?
No, sir.
That's right.
That's
I recall in the first statement that she gave to you, November the 18th, 2020, that she was extremely emotional, was she not?
Yes, sir, she was.
And at one point in time, you told her, did you not, don't blame yourself for this?
I don't know how you do the words. You have to look back. I recall saying, you couldn't have known while I was speaking with her what was going on.
But, once again, the jury can recollect for themselves what they heard you say.
Yes, sir.
So I take it at some point in time between the first interview and the second interview is when you gathered information from either the coroner or people at the hospital or something.
Between the first and second interview, at one point I was contacted by the coroner and Galvin.
All right. And I think you personally met with him
I spoke to him on the phone
for how long a period of time?
a few minutes.
A few minutes. And did he ever reduce to writing anything that he told you?
Well, I'm sure at some point he did, but I didn't have that at the time. I
Okay.
wrote down what he said as he said it.
Oh. Did you later learn to understand that what was the reason for the delay in the autopsy report? Do you know?
I believe workload from GBI.
Okay. Was there any concern about any toxicology reports or any other reports that GBI needed to do on the child's blood?
Yes, sir. All that was concerned being waiting for by the sheriff's office.
And I mean, if you left in February of 2021, that was only like 2 or 3 months. Is that correct from the date of the death?
Yes, sir.
Okay. Would it surprise you to know that the autopsy report was not done until the end of September of that year? I mean, you were already gone by then.
I was gone, yes, sir.
Did you ever have a chance to go over the autopsy report?
No, sir.
Were you ever asked by the district attorney or anyone else in law enforcement?
I recently went over pictures from the apartment, but I did not go over the actual autopsy report.
And the pictures that you described, those are the ones that basically we've seen, well, you weren't in here, but the photographs that were taken by Investigator Herrera.
Yes, sir.
Now, the interview that you did with Ms. Davis on December the 7th, that was played yesterday, and part of today, that didn't include the entire conversation that you had, is that correct? Or do you remember? In other words, do we see everything?
Yes, sir, as far as I'm aware, I don't recall any other interviews with her that's not recorded. That's what you're asking.
Well, I mean, what I'm saying is there was more to the interview than what the jury is saying.
I concluded the interview at the end of this. And in this interview, she left.
And once again, she was not placed under arrest.
No, she was never in custody.
At any, did you seek warrants against her?
No, sir.
Did you seek warrants against Mr. Benson?
No, sir.
Would that have been your responsibility to seek warrants?
No, sir, not necessarily.
Whose job would it have been?
These type of cases, these cases get forwarded to the district attorney's office.
So there were never any warrants that were taken against Ms. Davis?
I never took a warrant against Ms. Davis.
Then are you aware, based on what you know of the case, that there were never any warrants taken against Ms. Davis?
John, can we approach?
Yeah.
Sergeant, let me ask you a few more questions, if I may.
Yes, sir.
From the period of time that this event occurred until you left the employee of the sheriff, did you talk to Ms. Davis any other time besides in the office of their sheriff's department?
I made contact with her by phone.
By phone? Did she ever make contact with you by phone?
She returned the call.
And would this have been after the conversation that you had with her on December the 7th of 2020?
Yes, sir.
In talking with her, did you advise her that you were leaving the sheriff's department and then be turned over to someone else?
I don't recall doing so.
Okay. Just a second, John.